Fiscal Ethics Commission. This hybrid meeting is being held pursuant to the 45th Supplement to Mayor's Proclamation declaring the existence of a local emergency dated February 25th, 2020. The minutes of this meeting will reflect that charter created city commissions and boards that did not advisory bodies are now holding hybrid meetings in person and online subject to conditions of that proclamation supplement. Before we proceed, I'd like to explain some procedures regarding the format of today's meeting. Members of the public may attend in person and provide comment here in our meeting room. Members of the public may also observe the meeting remotely by electronic means and are offered the opportunity to provide public comment remotely by phone or through the WebEx platform as detailed in our agenda. Commissioners, members of the public, and others who attend an in-person meeting must comply with applicable city health orders and Human Resource Department guidance for use of the facility in which the meeting occurs. Today's meeting is being live cablecast on SF.gov TV2 and streamlined live online at sfgovtv.org/ethicslive. Mr. Moderator, please explain for the public's benefit how the public comment will be handled today. Mr.
Thank you, Madam Chair. Yes, thank you, Madam Chair. Public comments will be available on each item of this agenda. Each member of the public will be allowed 3 minutes to speak. For those attending in person, opportunities to speak during the public comment period will be available in room 400 City Hall. For those attending remotely, opportunities to speak during the public comment period are also being provided via phone call by calling 1-415-655-0001. Again, the phone number is 1-415-655-0001. Access code is 24938961078. Again, 24938961078, followed by the pound sign, and then press pound again to join as an attendee. For callers, you will hear a beep when you are connected to the meeting. You will be automatically muted and in listening mode only. When your item of interest comes up, dial *3 to raise your hand and be added to the public comment line. You will then hear, "You have raised your hand to ask a question. Please wait until the host calls on you." The line will be silent as you wait your turn to speak. Ensure you are in a quiet location. Before you speak, mute the sound of any equipment around you, including television, radio, or computer. It is especially important that you mute your computer if you are watching via the web link to prevent feedback and echo when you speak. When the system message says, "Your line has been unmuted, this is your turn to speak," you will hear staff say, "Welcome, caller." You are encouraged to state your name clearly. As soon as you begin speaking, you will have 3 minutes to provide your public comment. 6 minutes if you are on the line with an interpreter. You will hear a bell go off when you have 30 seconds remaining. If you change your mind and wish to withdraw yourself from the public comment line, press *3. Again, you will hear the system say, "You have lowered your hand." Once your 3 minutes have expired, staff will thank you and mute you. You will hear your line has been muted. Attendees who wish to speak during other public comment periods may stay on the line and listen for the next public comment opportunity, and should raise their hand to enter the public comment line by pressing *3 when the next item of interest comes up. Public comment may also be submitted in writing and will be shared with the Commission after this meeting has concluded and will be included as part of the official meeting file. Written comments should be sent to ethics.commission@sfgov.org.
Okay, thank you, moderator. I now call the meeting to order. Clerk, please, roll call, please.
Commissioners, please verbally indicate your presence by saying aye. After your name is called, Commissioner Bush,
Commissioner Bush is participating virtual. He met the new guidelines for COVID protocol, and I know that he's participating online, so he is present. I'll check in for him.
thank you, Chair Lee. Commissioner Flores Fang,
Aye.
Commissioner Finliff,
Present.
Chair Lee,
Present.
Commissioner Romano,
Present.
Chair Lee, with 5 members present and accounted for, you have a quorum.
Okay, thank you. Now let's go to agenda item number 2, public comment on matters not appearing on the agenda.
Thank you, Madam Chair. For remote participants, if you joined the meeting early to listen to the proceedings, now it's the time to get into the line to speak. Members of the public who are already on the line and wish to provide public comment on matters not appearing on the agenda under item 2 should now dial *3 or raise your hand in WebEx if you have not already done so to be added to the public comment line. Once you are in the queue and standing by, the system will prompt you when it's your turn to speak. We also ask that you please address your comments to the Commission as a whole and not to individual members. Madam Chair, we're checking to see if there are callers in the queue. Madam Chair, there's no callers from the queue.
Okay, thank you. With no public comment, now we are on agenda item number 3, which is draft minutes of the Commission's June 10th, 2022 regular meeting. Do we have any comments? Commissioner Bush? Colleagues, given the tech challenges that we're going to have today, I will use my prerogative to I will use I will call Commissioner Bush if he has any comments or suggestions first before we open up the floor amount. As I hope you will agree with this. Commissioner Bush, do you have any questions or comments on the draft minutes? If not,
Madam Chair, Commissioner Bush is not online yet.
okay. So, colleagues, do we have any comments? Anyone would like to make a motion to approve the minutes?
Ma'am, since this is the consent calendar, can we approve all 4 items at the same time? Or sorry, the 2 items?
2 items.
Through the chair, if I might, just to clarify, the consent calendar for today has 2 items. It's the minutes and the
And the
proposed resolution.
right.
We have the 2 stipulations not on consent for this particular meeting.
Thank you for that.
So,
Can we deal with items 3 and 4 at the
3 and
same
4?
time?
I'm sorry, so was that a motion?
The question is whether we could move to approve items 3 and 4 at the same time, since they're both on the consent calendar.
I think that's a question for the city attorney.
okay, so if that's the case, why don't we?
I'm sorry, I wasn't sure if my mic was on. Yes, we can go ahead and approve items 3 and 4 at the same time, provided that no commissioners want to sever either item, and there is no member of the public that wishes to comment on either item.
Okay, so
Thank you.
why don't we go to public comment to see if there's any comments on agenda item number 3, which is the draft minutes, as well as the resolution on the continuation of remote hybrid commission meetings first, before we make the motion. So do we have any public comment, Mr. Moderator?
Thank you, Madam Chair. Let me check if there's any callers on the queue. Madam Chair, there's no callers in the queue.
Okay, thank you. Public comment is closed. So do I have a motion to approve consent calendar items 3 and 4?
I move to approve the draft minutes in item 3 and to approve of the resolution in item number 4.
Seconded.
Okay, moved and seconded. Roll call, please.
On the motion to adopt the consent calendar, Commissioner Flores-Fang,
Aye.
Commissioner Finliff,
Aye.
Chair Lee,
Aye.
Commissioner Romano.
Aye.
Madam Chair, with 4 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Okay, thank you. Now we go to agenda item number 5, which is proposed stipulation, decision, and order in the matter of Gabriela Lopez. Need any report from the staff?
Thank you, Chair Lee. This is Pat Ford, Director of Enforcement. This stipulation is before you under the streamlined administrative resolution process, which is a way to resolve violations through a more streamlined process that sets a fixed penalty. So that's why you see at the bottom that because the respondent in this case took the remedial action and cooperated with the investigation and resolved the violations within 60 days, that it's pegged to a particular amount that you see at the bottom, and be glad to answer any questions you might have about this. But that's the main context. And this is a Form 700 disclosure case.
Okay, thank you, Director Ford. Commissioner Bush, do you have any comments or questions? No. Fellow commissioners? Commissioner Finlap.
Madam Chair, thank you. I have a couple of very quick questions. One is a general question about the stipulation process, Mr. Ford. I know that we can reject or approve a stipulation generally, but what happens if we just ask you to do some additional work and come back at the next meeting as a non-rejection? Does that somehow void the stipulation, or it stays live until the commission either approves or rejects it?
I think, yeah, if you have any issues with the stipulation and the commission does not vote to approve it, we would have to go back and do that additional work, whatever that may be, and then we would have to talk to the respondent again, and we would have to seek the respondent's agreement to whatever the new terms of the stipulation might be. And if the respondent doesn't agree to that, then potentially we would have to initiate a hearing through the commission's hearing on the merits process.
Right, but if we don't require any actual changes in the stip, if it's purely a matter of putting it over for a month without changing it, does that somehow void the stipulation, or it stays kind of binding until we act on it?
Oh, I understand. Yeah, if you were to continue it to a future meeting and consider it again in the same form, I don't think that would change the terms or the posture in any way.
Okay, and thank you. That was a general question. It was not specific to this particular stipulation. But on this stip, there are kind of 2 quick questions I had that I was curious about. If you can't speak to it because it's outside of the stipulation, that's totally fine. I noticed that the stipulation notes that the investigators found no evidence that MNC had contracts with the school district, MNC being the Mission Neighborhood Center where Ms. Lopez was working. But I'm wondering whether MNC sought city contracts during that time. And I assume if they had, it would be public, so maybe you can discuss it. But if you can't, no need to. And I'm also curious what Ms. Lopez's role was as chief academic officer. Again, if you can't speak to that, that's fine. In future situations, I think those are kind of the helpful facts to give us a little more information. Those are not issues that would stop me from approving this, but by any means at all. I'm just kind of curious, and I'll see if you can respond to it. If you can't, I understand.
Sure. No, thank you, Commissioner Finlep. I think those are both really good points of feedback. We'll work on incorporating those kind of facts into future STIPs. We did not find any evidence of that organization seeking contracts with the school district. The Form 700 disclosures pegged to whether or not the official gets income from an organization that does certain kinds of work that the agency they work for would contract for, not necessarily that the agency does contract for. So we don't really hone in on that in particular, and we didn't see any evidence of that in this case. And certainly, had the respondent in this case considered or taken any action on that particular source of income, that would have been a whole different matter. that would be a conflict of interest, and we didn't see any evidence of that in this case. Here it's just the reporting. But to answer your question, no, we did not see that in this case. And as to the details of her role, I don't know offhand. We didn't include that in here. We just know that she did receive income, but that's absolutely something we can include some more facts on in the future.
Great, thank you. And then I'll just note for the record that Mr. Ford is growing a wicked beard. I feel like we should all note that. But thank you. I think this is a great stipulation and good work.
Okay.
Thank you, Commissioner.
Any other comments? If not, let's, do I have a motion to approve?
Move to
So
approve.
moved.
Commissioner Bush, is that you?
Yes, I move the motion.
Okay,
Seconded.
okay, it's been moved and seconded. Public comments, please. Moderator, do we have any public comments?
Please stand by for while we check for callers in the queue.
Okay.
Madam Chair, there's no callers in the queue.
Okay, no public comment. For agenda item number 5, it's been moved and seconded.
Yes.
Moved and seconded. Roll call, please.
On the motion to move, Commissioner Bush,
Aye.
Commissioner Flores-Fang,
Aye.
Commissioner Finliv,
Aye.
Chair Lee,
Aye.
Commissioner Romano.
Aye.
Madam Chair, with 5 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Okay, thank you. Agenda item number 6, proposed stipulation, decision, and order in the matter of Darryl Honda, SFEC case number 2021-026. Director Ford?
Thank you, Chair Lee. This is another stipulation that pertains to Form 700 disclosure, which again is the disclosure of personal financial interests by city officials. However, this is different. This matter was not resolved through the streamlined administrative resolution process. It involves a much higher number of interests that were not disclosed on the Form 700, which persisted across multiple years. So here we have 37 sources of commission income, meaning income that was paid on a commission basis. And that was not reported on 4 separate Form 700s. Commission income has to be reported if it's $10,000 or more. You have to report the actual source of the income. Here that was not done. The respondent did cooperate with this investigation by filing amended Form 700s to disclose the interests that were not disclosed. And for that reason, you see the penalty calculation on the final page of the stipulation. The interests, there were 37 of them. This penalty pegs to $600 per omitted interest for a total penalty of $22,200. I'm glad to answer any questions that you may have about it. And also, I do want to point out that Mr. J.P. Fisher, who's the respondent's counsel in this matter, is present today remotely, and he's agreed to make himself available if you have any questions as well for him.
Okay, Vice Chair Bush, do you have any comments or questions for Mr. Ford?
Yes, thank you. I received a copy of a communication from Jerry Dratler raising questions on whether the disclosure was adequate and sufficient. Does Mr. Ford have a response to those questions he raised by Mr. Dratler?
Thank you, Commissioner Bush. I'm not sure that I've seen this communication from Mr. Dratler that you're referring to. With this stipulation and the amended filings that the respondent has filed reflect all of the financial interests that we were able to discover through the investigation. So we believe that they are complete at this time.
Well, he raises a number of specific examples for periods of time where there was not a disclosure. And I just would ask that you give a quick eye glance down that and then give us some feedback. Thank you.
Yep, I'll be glad to do that, Commissioner Bush. And one thing I think is worth pointing out is that any stipulation that the commission approves is limited to the violations that are noted therein. It doesn't prevent the commission or the enforcement division from looking at future or other violations by that respondent.
That's helpful. Thank you.
Okay. Director Ford, I have a quick question. This is highly unusual, and it really differs from other items that come before, proposed stipulations that come before this commission. My question is, this has covered 4 years while Mr. Honda served on the Board of Permit Appeals. Was there any effort to look at some of the actions taken during those 4 years, comparing to the commission's, the sources that they had received during those time that he had neglected to put in the Form 700?
Thank you, Chair Lee. Yes, we definitely did that. We did do a very close review to try and understand if Commissioner Honda did take any actions that would have had a material financial impact on those sources of income, and we did not find that. We did find that he recused in a handful of cases, and we didn't find any additional cases where he took a vote that would have been in violation of conflict of interest laws.
Okay, thank you.
So, Mr. Ford, this is Commissioner Romano. I have a couple of questions. As I understand it, Mr. Honda did disclose the income. He just didn't disclose. He said that the source was the real estate agency, not the individuals themselves. Is that the essential allegation?
Yeah, that's correct.
And as a matter of law, what's the required knowledge element of violating the law? It has to be intentional deception, or is it just if you errantly file a 700 form that doesn't identify the source properly, then you violate it? Or does there has to be some intent element?
It's the latter. It's essentially strict liability. I mean, you're required to disclose the sources that are disclosable under law, and if you don't do that, that's a violation. Obviously, if there are any facts that indicate willfulness or an intent to hide or obscure sources of income, that would absolutely be aggravating and would result in a much larger penalty. I mean, as you can see from the stip, this penalty does not reflect the maximum penalty because we did not find those facts in this case. We did not see the respondent or any evidence that the respondent was intentionally trying to do this. However, he did fail to disclose over a series of years, which we do think is pretty serious. So that's why you do see this as a substantial penalty.
What would be the minimum penalty in this situation?
I'm not sure that there's a minimum penalty that's specified in the regs or elsewhere. We pegged this roughly to what the streamlined administrative resolution process sets up for omitted interest. We thought that although this was not eligible for that process because of the number of violations and how long it did take to resolve this, to get the amended filings completed, we still did think that $600 per omitted interest resulted in a substantial enough penalty that it would serve as a pretty strong deterrent to anyone else who might not be disclosing commission income.
Thanks.
Questions? Okay. Do we have a motion to approve the stipulation?
Larry has something to say.
Oh, sorry.
I would just like to suggest that the training that we are anticipating in the future should reduce the confusion for filers in the future.
My apologies, Vice Chair Bush. Can you repeat your comment? I couldn't hear it very well.
I thought that our system of providing training for Form 700 filers will reduce confusion in future filings.
I think it does, but I think this, he had resigned earlier this year. So I think moving forward, we would have a more robust training and accountability system for Form 700 filers, right? So,
Good, thank you.
okay, I think we have to make the motion first and then. So do we have a motion to approve this stipulation before we open up for public comment?
I move that we approve it.
Okay, second?
Seconded.
Okay, let's open up for public comment. We have one commenter at the, in the room, so caller, please begin. Who's timing this? Okay, you have 3 minutes.
Hello, Speaker. You have 3 minutes. Once 3 minutes are up, I will go ahead and mute your mic, okay? Ready?
Good morning. My name is Darryl. Mr. Honda was the president of the Board of Appeals, an important position. The stipulation agreement addresses Mr. Honda's failure to report 37 sources of commission income between 2018 and 2021, a 4-year period. Mr. Honda served for 10 years and failed to disclose his ownership interest in 8 properties. These additional violations should be a consideration in determining the amount of Mr. Honda's penalty. I sent you a copy of the amended 2017 Form 700 Mr. Honda filed 6 months ago on October 14, 2021. Mr. Honda did not report the 8 properties he owns on that filing. The only accurate Form 700 Mr. Honda filed in 10 years was the form he filed on leaving office on July 1st of this year when he signed the stipulation agreement. The Form 700 includes 3 additional schedules Mr. Honda failed to file 6 months earlier on October 14, 2021. The penalty assessment section of Exhibit A states the Ethics Commission may consider the relevant circumstances surrounding this case. The relevant circumstances in this case indicate Mr. Honda should be required to pay between $185,000, $5,000 times the 37 violations, and $1.1 million, 3 times the amount Mr. Honda failed to report in the 4 years. I doubt the Commission has seen another case with 37 separate violations, the willful filing of false Form 700s over 10 years, and a demonstrated intent to conceal the ownership of 8 properties. A penalty of more than $185,000, but less than $1.1 million is appropriate. Director Pelham is proposing the Commission approve a $22,000 penalty. The proposed penalty is 12% of $185,000. I would like an explanation of why Mr. Honda is entitled to receive an 88% discount off the minimum penalty. I believe a $500,000 penalty is appropriate. Thank you.
Have any other in-person commenters? If not, Mr. Delgado, can you check and see if there's any public comments?
Thank you, Madam Chair. There's 2 callers on the queue.
Good morning.
Welcome, caller. Welcome, caller. You have 3 minutes beginning now.
Good morning. This is Stephanie Peake. Mr. Honda has withheld information about his income and his real estate. So I really think it's only fair that you make his punishment commensurate to his crime in order to promote ethical behavior, to encourage ethical behavior. And by the way, in last May at the Board of Appeals when Mr. Drattler brought an appeal. Mr. Honda did not recuse himself, although he did have a conflict of interest. Thank you very much.
Thank you. Next caller, please.
I'd like to, hello, my name is Dennis Richards. I'd like to help the commission understand how we got to this point and put this in context. In February of 2021, in a sworn deposition on Richards Six Dogs LLC versus the City and County of San Francisco and BVI, Mr. Honda said that he was SIA's real estate agent and that he's always recused himself from SIA projects. A Mission Local article appeared in October of 2021 questioning Mr. Honda's failure to recuse himself from 2 SIA projects. 2 days before the article came out, Mr. Honda filed amended Form 700s. In December of 2021, he came before the Rules Committee with his attorney, Mr. Fisher, and asked for a continuance because they needed to gather the documents and there was some confidentiality and there was some confusion that he didn't understand how the filing should work. In May, he came before the Rules Committee live at City Hall. He still failed to report his ownership interest in 1161 Post Street. He stated he didn't understand, he was confused by how to fill out the forms despite all the other commissioners and board members who can seek assistance from the city attorney or the Ethics Commission. Subsequently, he resigned from his position at the Board of Appeals because he was facing a removal hearing for misconduct at the full board. Aside from the July 22nd filing, or the July 2022 filing of his Form 700, I question whether Mr. Honda has ever filed a truthful Form 700. And I challenge you to please do not approve this. Go back and look further at all of Mr. Honda's filings in their entirety. There were willful omissions. There was an attempt to conceal potential conflict. There was repeated and a clear pattern of obfuscation. Mr. Honda's actions were neither transparent nor accountable. I ask you to please send a clear message to defer this kind of behavior in the future and to not approve the stipulation and to send a message and fine Mr. Honda the minimum of $185,000. Thank you.
Madam Chair, there are no more callers on the line.
Public comment is closed. Director Ford, you mentioned that Mr. Honda's attorney is available to answer any questions. Is he still on? Do you know?
Yes, I see him here.
Okay. First, Director Ford, given the couple of comments made by the callers, can you shed some light to those comments?
Sure, yeah, glad to do that, Shirley. Yeah, I mean, maybe first of all, it's good to reiterate that approving this stipulation, again, does not preclude the commission or the enforcement division from looking at other violations by this individual that are within the statute of limitations. So if members of the public believe they have evidence of a conflict of interest, that's absolutely something we could look into. Approving the stipulation for these particular reporting violations, which are solely about the commission income, does not prevent us from looking at conflicts. But again, as I mentioned earlier, we did already look for that. We did not find any evidence of that. Had we would have included that in here, but we just did not find that through this investigation. Also, I think it's worth pointing out that there is no minimum penalty. There's a maximum penalty that's set forth in the charter, which is up to $5,000 per violation or 3 times the amount not disclosed, which, as we mentioned in the STIP, we believe that that's 1.1 million, but that reflects, again, the maximum penalty, and there is no minimum penalty in this case. We do believe in the context of other Form 700 penalties that have been assessed that this reflects a fairly robust penalty that we do think will serve as a strong deterrent effect.
Comments from, okay.
Thank you. Just comments. First, thank you, Mr. Ford, for reiterating that what we're dealing with today is purely the 37 commission sources. The commission is not saying that there was or was not other conflicts, or that the undisclosed properties are or are not an issue. Those are just not before us today, and we're not saying anything about those issues. And I want to remark that in a vacuum, this fine seems extremely lenient for 37 violations, but based on my understanding that the violations are all subsets of what Mr. Honda did disclose, it kind of makes sense. I still think it's on the lenient side, but within kind of a reasonable range. Had these been 37 standalone sources, that'd be an entirely, I think, different question. But my understanding is that those 37 sources are all of them subsets of the $100,000 plus income that Mr. Honda did disclose on the Form 700. And I'm hoping Director Ford can confirm that's the case, because that really, for me, changes the tenor of the penalty conversation. It's still lenient, but I think if that is the case, that these are subsets of what was disclosed, then it's within the reasonable range. Thank you.
And yes, I can confirm that, Commissioner Finleb, that Commissioner Honda did disclose his income from Zephyr or Corcoran Realty. It changed names at one point. But yeah, all of these sources of commission income that he failed to report, this is failing to specify the specific names of the clients that were parties to the real estate transactions that Mr. Honda was a real estate agent for, but he did disclose the income that he received through the brokerage. That he just failed to specify the specific names of the clients. So you are correct in your description.
Thank you.
Okay, Commissioner Romano?
Yeah, I just have two questions. Again, to Mr. Ford, I just want to reiterate to make sure that I understand. You found no evidence of willful deception. Is that correct?
Correct. We found a pattern over years, but we did not find affirmative evidence showing that he knew that he needed to disclose this, but nonetheless chose not to do that.
And my second question is, and you found that there were no actual conflicts between those, I guess we'd say clients or sources, and his position with the city?
That's correct.
All right. In that case, I actually feel that the penalty is harsh, not lenient. Thank you.
Okay, so with public comment closed, we have a motion on the floor, seconded. Mr. Clerk, roll call, please.
On the motion, on the motion to second, Commissioner Bush,
Aye.
Commissioner Flores-Fang,
Aye.
Commissioner Finley,
Aye.
Chair Lee,
No.
Commissioner Romano.
No.
Chair Lee, with 3 votes in the affirmative and 2 votes opposed, the motion is carried by 3-2 with Commissioner Chair Lee and Commissioner Romano in the dissent.
Okay, thank you. Now let's go to agenda item number 7, which is presentation, discussion, and possible action on proposed Ethics Commission ordinance for November 2022 ballot and amended Ethics Commission regulations to strengthen gifts and other cities' ethics law. Let's have our acting senior policy analyst, Mr. Michael Kenning, to give us a presentation and update.
Thank you, Chair Lee. I need the permission to share my screen. Alvin, can you make me a presenter? One moment. Caesar, Alvin, anybody able to make me a presenter?
Screen is not on yet.
That's not, okay, here we go.
Okay, yep, there it is. Thank you. Great. Is my screen visible?
We're able to see you.
Great. Okay, great. Yeah, thank you, Chairley and Commissioners. I'd like to give a brief review and update on the Commission's Government Ethics and Conflict of Interest Review project. Great. So, yeah, to briefly review, this is the project, which was started in September of 2020 when the Commission identified a review of the city's conflict of interest rules as a top policy priority. This project was seen as essential in light of ongoing investigations into alleged corrupt activity by numerous city officials and contractors that have been revealed over the last 2+ years. These allegations demonstrated an alarming level of unethical conduct in and around city government and its decision-making processes. This investigation led to federal criminal charges against more than a dozen individuals, including 2 city department heads and 2 city employees. This project has sought to learn from the findings of these various investigations, staff research, and stakeholder engagement to identify improvements to ethics laws and programs to prevent future instances
I'm on a phone call, a conference call.
And this project was broken into 3 phases. The first dealt with behested payments, and a report was published on that item in November of 2020, and we'll be discussing that item at the next agenda item in item 8. The second phase of the project focused on gifts, both gifts to individuals and gifts through city departments. 2 reports were published last year on those topics, and a third report was published on general ethics provisions. And we're currently looking at these last 2 phases of the project and considering them as a ballot measure and draft regulation amendments that are currently before the Commission. To quickly recap the proposals that are in this ballot measure and regulation amendments, the gift-related proposals from phase 2 include creating a local definition of the word gift in the campaign and governmental conduct code, expanding the application of the restricted source rule to prohibit other aspects of the gift transaction beyond just the receipt and solicitation of the gift by an official. That clarifies how the restricted source rule applies to city contractors, amends the restricted source rule to explicitly apply to individuals and entities that apply for or obtain permits, licenses, or other entitlements for use from a city department. Sorry, just notified my slides were not advancing. Has that changed now?
Yes.
Great. Okay. Well, excuse me. So yeah, yes. So still going great. Amending the restricted source rule to explicitly apply the rule to affiliates, which are directors, officers, and major shareholders of an entity that is a restricted source. 6, creating a single standardized disclosure requirement for payments made to city departments. And 7, amending regulations containing exceptions to the rule against gifts from subordinates in city code. The recommendations from phase 3 of the project dealing with essential ethics recommendations include strengthening the city's bribery rule by incorporating elements of the federal bribery rule into local law. Extending the annual ethics training requirement to all Form 700 filers in the city. Codifying the rules that are currently in departmental statements of incompatible activities, or SIAs, into the code and discontinuing the individual department statements of incompatible activities. Standardizing penalty provisions to clarify that violations of local ethics rules have a strict liability standard. Ensuring any legislative amendments require approvals by a supermajority of the Ethics Commission and the Board of Supervisors, and adding general provisions that allow the Commission to require electronic filing of public disclosures. To recap the stakeholder engagement and the deliberative process the Commission has taken on this project and these recommendations, there were 4 interested persons meetings held last year. The Commission issued 3 reports articulating the evidence and rationale for all of the reforms being considered. The Commission has been engaged with city bargaining units through the meet and confer process. This item has been regularly discussed at commission meetings throughout the last year. And additionally, staff have had multiple one-on-one conversations with stakeholders on these reforms and their potential impacts. And this process has led to several revisions to the ordinance and regulation amendments that are currently before the commission. And these are changes since the last version, which was shared with the commission in February. I'll briefly recap the changes since those February versions. Most of these should be familiar as they've been presented at previous meetings, at least in concept form or in some cases with draft language. The first change is a proposed expansion, that the proposed expansion of the restricted source rule definition is narrowed regarding how seeking, obtaining, or possessing a license, permit, or other entitlement for use can make someone a restricted source. The second revision would remove the liability for the giving of a restricted source gift and place the responsibility for prohibited gifts on the city officials to not accept them and not on the givers of the gifts, with the exception of lobbyists and permit consultants who would be prohibited from giving a restricted source gift. The proposal has also been revised to extend the operative date of the ordinance and regulation amendments so that it would be 6 months after the effective date. The effective date is typically 10 days or so after the election results are certified. And then the operative date is the date where the kind of rules actually go into effect. And that would be proposed as 6 months from the effective date, which would allow for additional training to be developed and shared with city officials prior to the rules fully going into effect. Additionally, clarifying language has been added around how administrative penalty liability works associated with sections 3.1-102 and 3.1-102.5, also on that engagement with city officials a non-compensated volunteer activity for 501c5 organizations would not be incompatible, and to more clearly spell out the process and timeline for advanced written determinations. The revised recommendations also address the regulations, and these have also all been presented in at least concept form before, but regulations, the exception to attending nonprofit fundraisers has been revised, as well as the exception for attending arts and entertainment events. An exception is added to this version to allow the acceptance of personalized greeting cards, as well as payments provided at a free or discounted rate to members of the general public that are offered regardless of the city official's status as a city official. And an exception for branded promotional items of nominal value from nonprofit organizations. So for an update on the meet and confer process, as the commission is aware, state law requires the city to meet and confer with employee bargaining units before taking actions that would impact city employees' working conditions. Since November, staff have met with the Municipal Executives Association 9 times and have exchanged numerous written proposals regarding the proposed ordinance and regulation amendments. As of today, the meet and confer process has not been concluded. Staff and DHR negotiators are currently working to schedule an additional meeting with MEA. And I'd like to remind the commission that there is a potential closed item scheduled for an agenda item 10, where there'll be an opportunity to speak directly with DHR negotiators in closed session. Recommended action, given the August 5th deadline to place a measure on the November ballot and the ongoing status of meet and confer, staff is recommending that the commission vote to call a special meeting between now and August 5th to continue consideration of the ordinance and regulation amendments. This would provide additional time for additional meet and confer meetings and preserve the ability of the commission to potentially act prior to the August 5th deadline to place a measure on the November ballot. And with that, yeah, I will conclude and leave you all with the quote that tend to end these on, which is that government decisions of officers and employees of the city and county should be and should appear to be made in a fair and impartial basis, which comes from our city code and is one of the driving forces of these recommendations. Happy to take questions.
Thank you, Mr. Kenning. Vice Chair Bush, do you have any questions, comments?
No, it seems like a pretty comprehensive overview, and I appreciate the effort that went into it.
Okay. Fellow commissioners, any comments? Commissioner Finlap.
Thank you. I do have some questions about just the language of the proposal itself. I feel like we've spent a lot of time talking about moving this forward, but relatively little time talking about the actual product that we're working on. So I wanted to just ask Mr. Kading a couple of quick questions. One key piece of this is getting rid of the state definition of gift and having our own city definition. So I'm just curious if you can remind us what are kind of the key differences in terms of what is considered a gift under state law, but will no longer be considered a gift under our local law. And what I'm getting at is what are the specific problems that this addresses? I'm sure there are problems, but I'd like to get an understanding of what this actually means in practice. What gifts will no longer be considered gifts, such that they're not. I'm sorry, what?
Yeah, happy to speak to that.
Thank you. And sorry, just before I let you, sorry, Mr. Kading, didn't mean to cut you off, but just for my colleagues, I'm looking at the definitions in section 3.203, the definition of the word gift. It's on page 57 of the exhibit 1, attachment 1 to this item, which is, got it, page 67 of 203 of the entire packet. A couple different page references there, but I think we got there. Thank you, Mr. Canning. Sorry to cut you off.
Yeah, it's no problem. Thank you, Commissioner. So the main, the actual definition of gift does not have a lot of differences between what we're proposing and what's in the state rule. However, the main difference would be the exceptions to what is considered a gift. The state gift rules are based on Form 700 disclosure and the annual gift limit, and they apply very broadly to anyone, kind of regardless of what the relationship is with the city. So you might want to have, so the motivation for having those exceptions are a lot broader. Whereas our gift rules are narrowly applied to restricted sources. So those are folks who have business before the official's department or have attempted to influence that official. So a lot of the exceptions that the state offers end up not being appropriate for the restricted source rule. And this also touches on the changes to bribery, where currently we define a bribe as a gift, which means that all of those state exceptions are also being applied there. So even in a situation where it is a bribe was being made, if the person offering the bribe was exempt from the gift rules at the state level, we wouldn't be able to pursue that bribery charge.
Well, I think under your proposal, bribery is no longer based on a gift. It's anything of value. So I think
correct. That's solved by that.
But on the gift, I think for me it'd be super helpful to have a kind of specific sense of how the exceptions play out in the real life. So maybe not today, but at a subsequent meeting, if you could have a list of just practical examples of things that are exempt from the gift, things that under state law are considered gifts that would no longer be gifts under our local law, under the exceptions that we're proposing to get rid of. I think that it'd be helpful to know just in practice what this actually means.
Yeah, I can definitely put that together. And also in the gifts to individuals report that was published last year, we list through those every gift exception at the state level and talk about whether or not how appropriate it is to the restricted source rule. And that's sort of the determination for the recommendations in the regulations around which of the state exceptions to carry over into local law. But yeah, in that document, we run through all of the state gift exceptions and then talk about whether or not they would be applicable for the restricted source rule or whether or not they undermine the restricted source rule.
It would be, sorry to interrupt, it'd be really helpful just to have a clean answer to the question about what would be a gift under state law and what is exempted from being a gift under this proposal, rather than going through all the rules and the exceptions to the exceptions.
You can work to follow up on that, but yeah, the exceptions are kind of what defines the gift. So it is a bit of a.
That's why Commissioner Finlev was asking for specific examples so we could understand what's really going on.
follow up with that.
Thanks.
I have a couple other questions about the language, but I want to give my colleagues a chance to pipe in if they have other questions. On the definition of bribery in 3.216, that's on page 60, just a few pages further along. The underlying language being what is proposed, and I'll just read out loud the sentence. The bribery would be defined, or sorry, the first prohibition would be, no city officer or employee shall solicit for the benefit of any person or accept anything of value or contribution from any person with the intent that the city officer or employee will be influenced or rewarded thereby in the performance of any official act. Obviously, bribery is bad. Bribery is illegal under state law. It's so far not specifically prohibited under city law. So as I understand it, this would allow the Ethics Commission to investigate bribery. Currently, the DA can investigate bribery, of course. But the word rewarded in that sentence I just read kind of intrigued me because I'm not sure what rewarded does that influence doesn't. And my concern is that this would literally, I think, if you take it at its face, for example, a city bus driver would be committing bribery if they accept a box of chocolate from a happy passenger, or a firefighter accepting a gift from a citizen whose cat was saved from a tree. I don't think that's the intent, but I think if you read this literally, it will prohibit a city officer from accepting anything of value from anyone to reward them from their official act. I'm not sure that's what's intended, but I think if you read it literally, that's what it might do. So I'm curious where the word rewarded comes from, if that's, because I haven't seen that in other kind of bribery sections. And my concern is that it doesn't add much, but potentially creates unintended consequences. I think the word influence carries a lot of weight, as it should, and that's kind of traditional bribery language. So I'm kind of airing that concern that we don't inadvertently prohibit probably non-problematic behavior.
Yeah, thank you, Commissioner. I don't have the exact comparison up between what's proposed and what's in state law, but can definitely follow up on that reward language and get back to you on that.
And again, to put a fine point on it, I just think the language may be overly broad and not get at actual bribery. So that's my concern there. The word reward is also in the subsection 2 of the same prong. And I'll keep going unless someone jumps in. I have a couple other questions I want to talk about. On the next page, page 61, we're talking about restricted source rules. We had spoken about getting rid of liability for the giver, the non-city employee giver, that the liability should fall on the city employee. But I think subsection 6, which is on page 62, which talks about a person using a payment as an intermediary. I'm concerned that this section, because it's not qualified by city officer or employee, right? Subsections 1 through 3 talk about no city officer or employee. 6 just talks about no person. So I think what 6 might do is create liability for a intermediary from a non-city person. In other words, non-city person is a restricted source, gives it to a different non-city person. That intermediary non-city person provides it to the city officer. Now that middle person is liable, even though the original source would not be liable. I don't think that's the intent of what our prior discussions had been. And I don't know if it's just an inadvertent omission of the word city from the qualifying the word person, or if that's if there was something more deliberate behind it. So maybe you can just clarify that for me.
Yeah. I believe that is intentional, and the way that you read it is correct. That we talked previously about removing liability for the giving of a gift, but not necessarily for the serving as an intermediary for giving a gift, which is a different situation. But we could definitely, return to that if that's desired. But I think there's a higher sort of threshold of involvement for serving as an intermediary versus just inadvertently giving a gift. Yeah, your understanding of it is correct.
Yeah, okay. For me, it's the same concern. I feel like the source has no reason to know these rules, and for all the reasons we spoke about before, I think it's unfair to put criminal liability on a non-city person For the same reason, I think it's unfair to put potential criminal liability on a non-city intermediary. If the original source can't be criminally liable or civilly liable, why should the intermediary be? So I have the same concern. I think general liability should be for the city folks who we can actually train and have higher requirements for. We heard a lot of concerns from members of the public and from city partners about the chilling effect of these laws, about expanding potential liability to their conduct. All those reasons, I think, apply to this subsection 6 as much as it did to the original source. So I have the same concerns. I think number 6 should be limited to city employees, just like subsections 1 through 3. It's really the same reasoning. I'd welcome my fellow commissioners to share thoughts if they have on that.
Just on that point, this is Commissioner Flores-Fang. I completely agree with your point. I think it's been clear. I've also heard concerns, and I think it's the chilling effect is pretty. There's been an uptick in feedback, and I think it's significant, and it doesn't go unnoticed. And I think that just as we're doing here, I think are thinking about how to creatively engage to make sure that we're answering questions aside from the traditional means of calling the commission or calling the city attorney and emailing. But I think there are ways that we'd like to make ourselves available to answer any questions and to clarify how we can. But all that to say, I agree with your point, and I do think that the chilling effect is really unfortunate.
Okay. Any other comments? If
I
not,
have more comments on the language, not on that specific provision.
why don't you go ahead before we open up for.
Great, thank you. And thank you for indulging me. I think it's really crucial that we dig into the details of the language and not purely focus on kind of the timing. On page 66, there's the section about the statements of incompatible activities. Let's see if I got that right. Yeah, subsection A, and then subsection 1 below that A, activities subject to the department's jurisdiction. This was, and I want to thank Mr. Canning for incorporating my concerns that would allow folks to be involved in uncompensated volunteer activity. And this is a very nitpicky concern, but the first 4 lines, starting after the number 1, spell out what the prohibitions are. And then the second sentence says, but city officers may engage in certain conduct, blah, blah, blah. My concern is that there needs to be words something like, notwithstanding the prior sentence, city officers may do this. Because without that, it looks like city officers can only engage in those activities in the second sentence as long as they don't fall within the prohibition in the first section. I don't know if I'm saying that clearly, but I think there needs to be some kind of phrase that says, notwithstanding the prohibition in the prior sentence, city officers can do the following. Because without that, it doesn't look like a carve-out. It just looks like a separate kind of explanation of what city officers can do. I may be over nitpicky, but I don't think there's any damage in including that kind of extra wording that really clarifies that that even if we're under the first part of that paragraph, city officers can still do these following activities. And I hope I've kind of explained that in a way that makes sense, Mr. Canning.
Yes, Commissioner, that makes sense, and we can work with the City Attorney's Office to clarify the intent there.
I'm sorry to interrupt, Commissioner Finlev. I do just want to make sure I understand the comment. So is that you're addressing the language that appears on page 66, I believe, line 14?
That's right.
And you would prefer, I think, to not have the word but and have something like notwithstanding the foregoing sentence?
Yeah, exactly.
Something like that.
Exactly, yeah.
Okay, thank you for the clarification.
And that is very granular, but I think that clarity is important. And my next one is on page 67. This is more of a comment. Selective assistance. I love that selective assistance prohibition will now be codified in the code itself. Previously, as I understand it, that was purely in each department's statement of incompatible activities. But selective assistance, based on the practice of favoring the practice of city officers potentially favoring their friends or colleagues without a good reason, now that prohibition will be codified in the code itself. So I think that's a wonderful development. Thank you. Thank you, Mr. Canning, for indulging me, and Madam Chair, thank you. Those are the comments I had.
Thank you. There's no other comments. Commissioner Bush, do you have anything to add before we entertain any motion? Okay. Okay, so I think there are a couple of actionable items before us. One is the motion to schedule an additional, a special meeting before the August 5th deadline to further discuss this item and to take possible action. So, but before we proceed on that one, I just want to propose that we move agenda item number 10, the closed session update with labor negotiators, immediately after this one, because it makes more sense for us to continue the discussion. So if there's no objection, just want to let people know so that they can time themselves, especially for those who are participating virtually.
No objection to that, but I wonder whether it makes sense to have that conversation before we vote on scheduling a subsequent meeting, because that would inform the timing potentially.
Yeah, I just want to alert the public that we may be entertaining that one. We are going to take a vote right now on the motion whether to schedule a special meeting, and then we're going to open up for public comment on this particular agenda item. And if there's a vote after that, we will proceed to move agenda item number 10 right after this one.
Excuse me, I think I agree with what Commissioner Finlev was getting at, which is that the decision on whether or not to have an extra meeting in July before the 5th may depend on our closed session conversation. And so he's suggesting, and I think it's a good idea if it's permissible, no, to have the vote after the closed session.
Although I will say, I mean, I think there are other things on the agenda, like the behested payments, other things that may need to be discussed before then, that may...
Before what?
Or to have a special meeting. I think that there's been, I mean, from what I saw, I mean, there's been a lot of feedback on behested payments, and I think that that's really on people's minds, and if it's pretty urgent, and so it could merit a special meeting.
So that could, another reason to delay the vote on whether or not to have a meeting.
Yes,
No,
yes,
my
I agree.
To the end.
understanding is this particular proposed action, besides the behested payment, because you're right, the behested payment does call for a special meeting for further discussion, and there's a time sensitivity in it. But for this particular item, staff is recommending that we hold an additional meeting before August 5th to decide on this particular case and whether to place this item on the November ballot. So I think the special, a possible additional meeting in July involves two items. This one as well as the behested payment discussion. So for this one, for this particular agenda item, the motion would be to hold an additional meeting before the August 5th deadline to decide whether we could place this item on the November 2022 ballot. Am I clear? Am I correct, Assistant Attorney? I mean, Assistant City Attorney? So we are, there are two proposed agenda items for a special meeting in July. This one, whether to place a ballot on the November election. The second one is to discuss the behested payment discussion that we will have later on today. So the special meeting in July would have two separate agenda item discussions.
I think that's accurate, right? That's all true. My only point is that the timing of any special meeting will be affected, for me personally, by whatever we might learn in the closed session. So my suggestion is have the closed session first, then vote on the special meeting. That's it. It's not to not have a vote on the special session.
I concur.
So I'd like to ask Deputy City Attorney Shen for your legal interpretation. Should we take the vote now, or should we hold off to the vote until we have the closed session?
Yeah, I don't think this is actually strictly a legal matter. This is more of a parliamentary procedural matter. But I don't want to get too ahead of ourselves, but I think there is broad understanding or expectation that there will be further July special meeting. We just don't know exactly when, and it's very likely that it will have these two items on the agenda. I don't think we necessarily need to come back to this item to close it out, and I think there will be opportunities later in this agenda, maybe in connection with the next item, maybe in connection with item 10, where we can sort of nail down those dates.
Okay, so
So it's up to the commission whether you want to consider the closed session now or later, but
I think you're saying there's no legal obstacle to us having the closed session first and then voting on a special session.
you could certainly do it either way.
okay, so why don't we do this? I still would want to open up for public comment on this agenda item without any action. And then after that, we are going to go to agenda item number 10 for closed session, and then we'll take up the proposed action. How's that?
Great.
Sounds good.
Okay, so Mr. Delgado, can you open up for any public comments?
Thank you, Madam Chair. We're checking to see if there are any callers on the queue to wish to comment on item 7. Welcome, caller. Your 3 minutes begins now.
Hello, I am Jennifer Wagner, San Francisco resident and small business owner. I'm speaking on behalf of the nonprofit League of Women Voters of San Francisco and as someone who has participated in multiple meetings about this agenda item. In addition, our organization's president, Allison Go, emailed comment strongly in support of placing the Ethics Commission ordinance on the November 22 ballot this morning to address alarming misconduct. The League supports regulations that ensure transparency, protect representative democracy from distortion by undisclosed contributions, and combat corruption and undue influence in government. Since September 2020, our League members have participated in the Ethics Commission's public process to improve ethics laws and prevent future instances of corruption in light of the ongoing investigations into alleged corruption by numerous city officials and contractors. These meetings have been very successful in addressing unintended unjust impacts and equity concerns, for example. It is unacceptable to delay these ethics reforms, whether due to meet and confer, closed session discussions, or minor reforms to the language, when there has been an extensive inclusive process and the need is great. We strongly ask you to do whatever necessary to meet the August 5th deadline to place an acceptable Ethics Commission ordinance on the November 22 ballot. Thank you so much for your consideration and continued work to protect democracy in San Francisco. Thank you.
Thank you, Ms. Wagner. Next caller, please.
Welcome, caller. Your 3 minutes begins now.
Good morning, Commissioners. My name is Charles Head. I am the president of the Coalition for San Francisco Neighborhoods, not of some, but for all neighborhoods. I'd like to echo the comments of the previous commentator. Get the proposal on the ballot ASAP. It's becoming increasingly frustrating to hear minor concerns, such as Commissioner Finley was mentioning about a bus driver receiving a box of chocolates as a reward for good service. Would this be considered bribery? You've probably read the writings in the Chronicle this week about arguments between Mayor Breed and the Board of Supervisors over the implementation of rules regarding Prop E, which was passed by the voters in June. For example, behested payments, the mayor wants defined as only more than $1,000, as an example. This is ridiculous. We need to get the proposed regulation on the ballot ASAP. Otherwise, this is just going to continue as ad infinitum. I have a friend that works for HR, and he said to me, Charles, look, these people are never going to willingly give up their power. They are never going to willingly give up their power to do whatever it is they choose, whatever it is they please. So please take this into account and pass the amendment out of committee or out of commission and onto the ballot ASAP. Thank you very much and have a good day.
Thank you.
Welcome, caller. Your 3 minutes begins now.
Yeah, my name is Francisco da Costa, and it's right that y'all first listen to the people. We are the ones, the advocates, who helped the Federal Bureau of Investigation, because they can follow the money to bring about the indictments. The Ethics Commission has failed us. So has the Sunshine Task Force. So has the controller. The mayor refused to sign a resolution sent to her on behest. What does that say? She doesn't give a hoot for the Ethics Commission. And most of y'all were not here 15 years ago or 40 years ago when all of us brought about the Sunshine Task Force and brought about the Ethics Commission. None of y'all were present, so y'all don't know how hard we fought so that we could have transparency and accountability. Y'all are into legalese, one word here, another word there. The main thing that y'all got to do is enforcement. Y'all don't even know Robert's rules. The chair rightly pointed out to you, listen to the public. Public comment is important. Some of you commissioners give a hoot. Let me tell you, as one who brought about the indictments with the San Francisco Public Utilities Commission, I give a hoot about the Ethics Commission. All of y'all, I give a hoot. There was one reasonable person who was a judge who's not there anymore. At one time, Quinton Cock was there, yes. It meant something. But this commission is just kicking the can down the street. Forget about legalese. We want enforcement. We want a strong ordinance, and we want strong language put before everybody in November. And this should have been done 3 months ago. We have a director of the Ethics Commission who is pussyfooting around. Stop this pussyfooting. Stop this pussyfooting. All these deliberations should have been in place three months ago. And you know that. I spoke to it. 3 months, we did the heavy lifting, the public. Not the Sunshine Task Force, not the Ethics Commission, not the controller. Thank you very much.
Thank you. Any other callers?
Yes, there's 2 more.
Okay.
Welcome, caller. Your 3 minutes begins now.
Hello, this is Sean McMorris with California Common Cause, the Transparency, Ethics, and Accountability Program Manager. We submitted some written comments late this morning, so I apologize, but hopefully you'll get them. Just wanted to convey that we support the draft ordinance as presented in item number 7. We had previously submitted comments stating that we supported it if the liability would be placed solely on the gift receiver. We would have training from City Hall, so that was to prevent, potential ensnarement of good actors who don't have the means to adequately navigate the law. So we appreciate that amendment was added, and the other amendments that were added, we believe, don't diminish the ordinance in any way, and that it's an improvement upon what current law is. So, and I listened to some of the comments that the commissioners made, and I can't speak for our board of directors, but I don't think that they would be opposed to any of the suggestions that came up. They seemed reasonable. So with that, I just we're hopeful that something will be able to be placed on the ballot in November. Thank you.
Thank you.
Welcome, caller. Your 3 minutes starts now.
Good morning, Commissioners. This is Debbie Lerman from the San Francisco Human Services Network. We agree that it is important to address the potential for gifts that create a true risk of corruptive influence in conjunction with existing bribery laws. But the devil is in the details, and this measure has huge potential for unintended consequences. The measure should be tailored rather than sweeping up normal activities that present no real risk of actual corruption. Several comments on this. First of all, nonprofit fundraisers. These provisions are improved, but it draws a senseless distinction between art and cultural and sporting events and all other nonprofits. There is a lack of equity in allowing art and culture organizations like museums or the symphony a privilege that is denied to other nonprofits. The same purposes apply in both provisions, whether it's assisting to maintain relationships and help raise money, or to monitor the activities and make future funding decisions. The measure should allow all nonprofits to provide one guest along with the public official attending. Secondly, we urge the Commission to exempt uncompensated nonprofit board members as restricted sources, as was done with behests. There are thousands of individuals who serve on boards. This is impossible to track. These are dedicated volunteers who receive no personal benefit from the nonprofit's contracts, and they would have no reason to offer gifts as a quid pro quo. Third, the measure properly restricts lobbyists as restricted sources, but the provision that refers to influencing or administrative or legislative action will turn hundreds of people into restricted sources merely because they express their opinion. Even without being personally liable, a public official receiving a gift creates the perception that the giver did something wrong when they didn't. It exposes public officials to liability that is impossible to track and interferes with normal day-to-day relationships. And finally, minimum threshold. This measure sweeps up day-to-day activities that have virtually no risk of corruptive influence, whether it's a box of cookies or a greeting card. Ethics staff responded to this concern by creating a few narrowly tailored exemptions like the greeting cards or branded promotional nonprofit items. But these were provided as examples of why the measure is problematic, and there are likely to be many similar examples with potential liability. The only threshold in the measure is $10 for refreshments during a site visit, and that amount is unrealistically low in San Francisco and doesn't even rise with inflation. We hope you will take these comments into consideration in determining the final measure. Thank you.
Thank you.
Madam Chair, there's no further callers on the line.
Okay, thank you. Public comment for agenda item number 7 is closed. So let's table this and proceed to agenda item number 10.
Can I just quickly before moving on, I do want to address some of the public comments, and just to say that for those of you who are paying attention, you should know that it's not only up to us about whether or not this measure can be placed on the ballot, and I assure you that everyone in this room and anybody working for the committee is working very hard toward that goal, especially Mr. Canning, Ms. Pelham, and Commissioner Finlev, and I appreciate all their extra work on this, so I just wanted to make sure that that was true.
That's why we're having a closed session to have an update with the labor negotiators. So let's go to agenda item number 10, which is a proposed closed session item for an update with labor negotiator regarding labor negotiations. This item has been scheduled for the Commission's discussion and possible action, employee relations staff, from DHR. They are here virtually with us for this closed session item. The anticipated issue and the negotiation is the status of the meet and confer with the employee organization, San Francisco Municipal Executives Association, regarding the Ethics Commission's proposed November 2022 ballot measure and regulation amendments. For the purpose of this item today, colleagues, we have 4 steps. First, under agenda item number 10A, we will receive public comment on all the matters pertaining to agenda item number 10, which include whether to meet in closed session. Second, we will then vote on whether to meet in closed session under California Government Code Section 54957.6 and Sunshine Ordinance Section 67.10 E to discuss labor negotiations. This will be an action item as noted in agenda item number 10B. Third, if a closed session is held, the Commission will initiate the closed session meeting to meet with the labor negotiator. Following that closed session, we will then reconvene in open session. The fourth is pursuant to Brown Act Section 54957.1 and Sunshine Ordinance Section 67.12, and as shown under agenda item, we will discuss and vote on the motion regarding whether or not to disclose any action taken or discussions held in closed session regarding the labor negotiations. So we've done this before several times, so unless there's any questions from a fellow commissioners, let's open up for, but before we do, I'd like to ask the Attorney Shen, is there anything that you may want to add to clarify? None, so let's open up to public comment.
May I just clarify before we go to open comment, which is just that we are not holding closed sessions in any way in order to shut out the public or anybody listening. They're required to have closed sessions for these labor negotiations. I think that we would all prefer to have them in public if possible, but we're required to do so.
It's a legal requirement that we have to abide by, but I agree with you totally. I would rather have all these discussions held in public. With that, let's open up for public comment to agenda item number 10, please.
Thank you, Madam Chair. Members of the public who are already on the line and wish to provide public comment on item 10, please dial *3 or raise your hand in WebEx if you have not already done so, to be added to the public comment line. If you have not already, please press *3 or raise your hand in WebEx. It is important that you press *3 or raise your hand in WebEx only once to enter the queue, as pressing it again will move you out of the public comment line and back into listening mode.
Hey, Mr. Moderator, I am going to call on our first commenter who is attending in person.
Oh, sorry about that.
And thank you for coming in person. It's much, much better for all of us.
Hello, Commission. Thanks for having me here in person. I would like to ask, I'm actually here to have public comment on item 8, and I would actually ask that the Commission not go into closed session until the agenda allows for it to go into closed session for item 10, so that those of us who came in person and who are on the line can actually have our public comment on item 8, as opposed to bringing the meeting back into session and opening public comment up at that time. Thank you.
Are there other people here in person for item 8?
I'd like to ask a legal question for our city attorney. The reason why we're moving up the agenda item number 10 is because we're dealing with technical issues as well with our vice chair who is in transit. And this is an item that he's been working on for a long time, so we definitely do not want to lose him due to technical reasons. But I do very much appreciate you sitting through this morning
Can we hear
through our meeting. So I'd like to ask our city attorney if we can have a public comment on another agenda item and then go back later. But we will continue to proceed on the discussion on closed session, agenda item number 10. Can we do that?
Just to be clear, the ordering of these items is completely up to the chair and commission's discretion. But if you want to open up public comment on item 8, since we have at least one person here and maybe other people on the line waiting to comment on that item, we can take public comment on 8, let everyone say their views or provide their input, come back to this item, do the closed session, and then if the commission wants to have further discussion on item 8, the commission can go back and do so. Is that what the chair is proposing?
Thank you. So why don't we open up public comment for agenda item number 8. After we take the public comment, we will proceed to closed session discussion, agenda item number 10. After that, we go back to open session, and then we'll take up action on agenda item number 7, and then we'll have a discussion on agenda item number 8. And sir, I would love to have you stay on to listen into our discussion on agenda item number 8. So if it works for everybody, let's open up for public comment first on agenda number 8, which is presentation, discussion, and possible action on implementation of certain behested payment rules enacted in December 2021 and recent legislative developments. Please go ahead.
Hello, thank you to the commission for having me again, and thanks for accommodating me. I will listen to the discussion, but I would do it like most others and do it from the comfort of my living room on Zoom. My name is Sam Cobbs, and I'm the CEO of the Tipping Point Committee, and we have also submitted a letter to the commission in regards to the behested ordinance that has also been signed by other members of the philanthropic community. We're very concerned about unethical behavior at the highest level by city officials, and we applaud the commission and boards of supervisors for putting into place policies that restores the confidence in our political leaders. But we actually think that the behested payments ordinance, that the language is much too broad. And we would love for the language to be clarified, and more specifically that we, when it comes to interested parties, that we actually adopt the amendments that the mayor has proposed. We have cited in our letter that you will get several examples of initiatives that are happening in the city that would not be possible if the behested payment went forward as it is now, or if it fails short. We agree with President Walton's amendments, but we still think that falls short. So a couple of the items in the way that philanthropy has tried to work differently in the city of San Francisco over the last 5 to 10 years, but this ordinance would take us back to the past. And so in the future, philanthropy and institutions like mine have just funded what it was that we thought were cool things and that we were interested in. We never collaborated with government to say, what are the things that we need to do to help move our community and our community members forward? An example of that is during the pandemic, Tipping Point consulted with the Department of Public Health to understand where the communities that were most in need of resources to get equitable vaccines out to those communities. We didn't know that information. The only people who really understood that was the Department of Public Health, who advised us what communities we should actually send dollars to for equitable vaccinations. Right? With this ordinance, those conversations are no longer possible for us to direct dollars in that way. None of the philanthropic organizations that have signed the letters actually have any financial benefit in the decisions that our colleagues in city make. And so we're asking you to approve the mayor's amendments on who is an interested party for the behested ordinance. Thank you.
Thank you. Now let's proceed. Go back to agenda item number 10.8.
Phone.
I think you should check whether there's virtual public comment on this item, since we're now doing public comment on item 8.
Okay.
Madam Chair, we're checking to see if there are callers in the queue.
For agenda item number 8, right now.
8, yes. Welcome, caller. Your 3 minutes start now.
Hi, my name is Ahmed, and I'm speaking on behalf of the Service Providers Working Group for the Children and Youth Fund. We're made up of 70-plus nonprofits with the primary goal to elevate the needs of the youth and families in San Francisco and to advocate on behalf of the organizations that serve them. This comment is regarding the behested payments ordinance, Ordinance 232-21. Due to budgeting and allocation constraints, department heads and department officials often solicit philanthropic funding for programs and services provided by their respective departments to fill funding gaps without seeking and receiving personal benefits and/or favors. As the ordinance, as it stands now, the language, the department officials have interpreted the ordinance to imply that they can no longer solicit these funds in many cases and will be held liable in civil or criminal court if they do so. This unintended implication has far-reaching consequences for the nonprofit sector, service delivery in the city, and a direct negative impact on the well-being of the city's residents, especially those that need them the most. The nonprofit sector relies heavily on city funding along with philanthropic funds to function and provide much-needed services to the city's residents. While there are nonprofit entities that have resources to raise funds, smaller nonprofits who are likely led by and serve BIPOC individuals do not have the capacity to solicit funds on their own and rely on city funding to operate. Additionally, this raises concerns for nonprofit representatives that serve on city boards and commissions. The ordinance also threatens them with liability and jeopardizes their ability to do their jobs in support of their organization. We officially request a written clarification and/or a formal statement of interpretation of the ordinance that allows for city department and department officials to solicit and receive behested payments from non-city partners, including nonprofit community benefits organizations and foundations, and also to solicit behested payments to such an entity. The official communication should also explain when city department officials are permitted to solicit from nonprofit and private entities in the context of grants for city programs. As done for the Summer Together program for DCYF this year, it is not sustainable to operate on a case-by-case basis regarding the interpretation of this legislation in order for departments to get approval to support fundraising efforts for nonprofits in the future. Would also like to request clear guidance for nonprofit representatives serving on city boards and commissions on what activities are permissible or impermissible.
Caller, your time has expired. Thank you. Welcome, caller. Your 3 minutes begins now.
Hi, Commissioners. This is Debbie Lerman at Human Services Network, and I appreciate the Commission's flexibility on public comment. I am not calling on item 8. I respectfully remind the Commission that public comment was opened and not closed on item 10, the closed session, and that's what I'm calling about. I want to say that I would prefer to comment on 8 after the Commission has opened the item and engaged in the preliminary discussion and presentation, so that my comment can be better informed by the Commission's thinking. And so that's my comment. I will just ask that I be allowed to comment later. If that is not going to be allowed, then please let me know so I can immediately call back in again on item 10, on item 8. Thank you.
Ms. Leonard, please be assured, and everyone, please be assured, there will be public comment opportunities for agenda item number 10, and there will be also additional opportunities for public comment on agenda item number 8 after we hear the presentation from the staff, after we have discussion among the commissioners. So we are not going to shut off public comments on 8 and definitely not on 10. So, Mr. Moderator, if we do not have any more comments on agenda number 8, let us proceed to...
Well, I'm sure we still have people on the line.
Okay. would they prefer to comment after we have the discussion on the agenda item? After they hear from staff reports? Because we are going to have public comment on agenda item number 8 after the presentation, after the discussion.
We let everybody in the queue, just talk, and then they can revisit.
Okay. Mr. Delgado, how many more people do we have for agenda item number 8?
We have 3 more.
Okay, please proceed.
Welcome, caller. Your 3 minutes starts now.
Hi, my name is Robin Takayama. I started working at Public Works almost 6 months ago in contract administration, but I took time off today to speak with you as a San Francisco resident of over 25 years. Our interim director and all the colleagues I work with are dedicated public servants committed to following the rules in place to uphold the public's trust. There's a rigorous onboarding process. Training videos go over all the rules of being a responsible city worker with reenactments of scenarios we might encounter. I received the memo about behested payments in May. I understand the intent to avoid even the appearance of bias and bribery, but as someone this applies to, I had a lot of questions. Can a person who happens to be a city worker tell people about an exciting ticketed art event at a nonprofit organization? Can we invite people to a fundraiser we're attending so we don't have to attend alone? Can we email a GoFundMe to our condo email list after a beloved neighborhood vendor passes away? From my reading and subsequent conversations with higher ups informed by the city attorney, interested parties for public works could be anyone, so all fundraising must stop. My direct work with interested parties is limited to grant applicants. But when I did a web search on DPW and permits, interested parties is quite extensive, spanning requests from property owners for like street space or sidewalk repair permits, event planners and food entrepreneurs for temporary occupancy permits, and even tenants if they need a storage container permit. I have nothing to do with these permit approvals, but have many of these constituents in my friend network. I'm an engaged San Francisco resident. For a snapshot, my family was involved in the campaign for marriage equality. My husband delivered food to seniors during the height of the pandemic. My calendar is full of nonprofit art events that will get the city's economy moving again. All of these activities and services take resources. I've been told by professional fundraisers, which I am not, that we're not fundraising, we're friend raising, and I get it. My broad network, cultivated over decades with a shared commitment to social justice, this network wants to know about the things I'm involved in and care about. These are things that contribute to a better San Francisco. So I hope you can work on ways for me and other city workers to be the best San Franciscans we can be in our private life and as city employees and continue contributing to our community. Thank you.
Thank you.
Welcome, caller. Your 3 minutes starts now.
Good morning, commissioners. My name is Lisa Branson. I'm the Director of Partnerships at the Recreation and Park Department. And I want to start by echoing other speakers and say that the department welcomes anything that makes government better, fair, and more transparent. Partnerships don't work unless there's trust on both sides. In that spirit, though, I want to thank the commissioners for carefully considering the proposed amendments that both clarify the law and allow many beneficial partnership projects to move forward. We need clear, easy to understand rules so that we don't have to worry that good public servants are somehow violating the law by just working with community groups. Unfortunately, the definition of interested party is sweeping for a department that issues tens of thousands of permits a year, and means that just saying yes, could use your help to a community group could be construed as an illegal solicitation. The department has been especially hard as a condition that any permittee becomes an interested party, even if they're just using a park for basic recreational purposes. They're generally not valuable permits, but our permit staff does have to work with them to make sure that their setup and activities work in a particular space. We get hundreds of phone calls a week for advice on how to plan events and what spaces to use. The department really doesn't have any discretion to deny these permits. Parks are for the public, and they have a right to use these spaces without fear that they can then not partner with the department in the future. The department has been working closely with the city attorney since the law was enacted to ensure that we comply to the fullest, but it has created a great deal of stress and uncertainty that the amendments go some way to address. Of about 30 active partnership projects, we've paused about half of them while the city attorney determines if they can move forward. Impacted projects run the gamut from decades-long partnership with the National AIDS Memorial Grove and Stern Grove Festival to community-driven projects such as new picnic tables at a neighborhood park. Other projects, impacted projects include the $34 million renovation of Crocker Amazon baseball diamonds in partnership with the San Francisco Giants. That's paused because the team did a special event last year at a park and also gets permits to run its Junior Giants youth program. And I'm hopeful that someday we'll get to permit another World Series victory parade. Another impacted project is the $40 million renovation of Jackson Park, which we are advised can move forward, but only assuming the community partner does not hold any permitted events at their neighborhood park, which seems absolutely against public interest and good public policy on the use of the park. Projects that could not have happened under the current rules include Let's Play SF, a partnership with the San Francisco Parks Alliance that allowed the department to turn enough bond fund.
Thank you, caller. Your time has expired. Thank you. Welcome, caller. You have 3 minutes now.
Good morning, Honorable Commissioners. My name is Dylan Schneider, and I'm the Manager of Policy and Legislative Affairs with the Department of Homelessness and Supportive Housing. And I want to start by echoing the last caller by stating that we welcome legislation that makes government more transparent and ethical, which is why we are supporting the amendments to the current behested payments legislation that further clarify this law and provide clearer guidance to city staff so we can continue to comply with the laws in place and support our department in being ethical and transparent with the public. The current version of the behested payment legislation significantly impacts our ability to respond to the homelessness crisis that demands urgency and innovation. Our department's ability to discuss potential homelessness response projects with philanthropic partners has resulted in highly successful public-private partnerships, providing millions of dollars towards critical programming and has helped hundreds of households permanently exit homelessness. The majority of foundations that work to address homelessness ultimately seek to advance systemic policy change as an integral part of their mission, which places them in the gray area of the attempt to influence clause included under the definition of interested parties in the ordinance. This definition threatens our agency's ability to receive foundational grants or advise foundations on their grant making, which is why we are again supporting the proposed amendment to remove the clause attempt to influence from the interested parties definition of this legislation. I want to give an example of a successful public-private partnership that could not have happened under the current legislation, under the current legislation's attempt to influence clause, which was the city's first non-congregate cabin program. This pilot program was made possible by a partnership between the Department of Homelessness and Supportive Housing, Dignity Moves, Rescue SF, and Tipping Point Community, along with several other philanthropic partners, and served 70 adults experiencing homelessness by providing non-congregate cabins for them to temporarily stay in while accessing a permanent exit to homelessness. This is one of many examples, from new pilot programs to public-private campaigns that have housed hundreds of formerly homeless families and youth, to in-kind consulting services that supported critical and time-sensitive needs, such as our initiative to house the 2,000 guests in the shelter-in-place hotels, or to launch our department's Racial Equity Action Plan. We are committed to operating ethically and transparently and being held accountable to these standards as public servants. We appreciate your consideration of the proposed amendments. Thank you.
Thank you.
Welcome, caller. Your 3 minutes begins now. Welcome, caller. Your 3 minutes starts now.
Yes, can you hear me?
Yes.
Yes.
Thank you. Good morning, commissioners and staff. This is Hank Heckel, compliance officer in Mayor Breed's office. I would like to echo some of the comments that you've heard from department staff and members of the community regarding some of the issues that have arisen out of the behested payments legislation that was passed this year. It's a very significant piece of legislation that enacts major changes to existing law. Formerly, the behested payments system was really a reporting regime that applied originally to elected officials so that they would report solicitations from anyone from a governmental, legislative, or charitable purpose so that information was transparent and available to the public. There was local legislation a few years ago that expanded that to cover also commissioners as well. And through an executive directive from Mayor Breed, we extended that reporting requirement to department heads. This year, the city passed this legislation, which converts the reporting regime to a ban, essentially. It prohibits many types of public-private partnerships based on the relationship between the parties and the relevant city departments. It covers not only all of those officials that I mentioned, but also all Form 700 filers. That's over 5,000 members of city departments across the city. It imposes strict penalties of up to $5,000 for staffers that may be trying to do their jobs and work on public-private partnerships with philanthropists and with community groups that were formerly quite common and have been ongoing. But due to, frankly, a lot of the confusion that's been engendered by this legislation, the mayor's advised all departments to pause any philanthropic funding for key city initiatives or for charitable purposes to community benefits organizations until departments can vet compliance, because we know this is ethics legislation that creates personal liability on staff, and we don't want to put staff at risk. And so this has created really a tremendous burden to vet compliance. We understand that this legislation is well-intentioned, but unfortunately there have been some unintended consequences due to the breadth and the vagueness and the complexity of this legislation. Several members of the Board of Supervisors have voiced concerns about this, and really all parties agree that the legislation is well-intentioned, but needs to be clarified and refined and improved. And so there are a couple of sets of amendments before the commission, and we look.
Caller, your time has expired. Thank you. Chair, there's no more callers on the line, on the queue.
Okay, thank you. And again, just to remind the public that public comment for agenda number 8 is not closed, is suspended until we take up the matter again. So there will be additional opportunities for folks to speak on that agenda item. Now let's go back to the proposed closed session, item number 10. Let's call for public comment on that one, please.
Madam Chair, let me see if there's callers on the queue for item number 10.
I think Ms. Lerner was waiting for this one. She should be on queue. I mean, in the queue.
Welcome, caller. You have 3 minutes. Madam Chair, there's I guess that the call drop, so that was the only hands raised.
More callers?
No, Madam Chair, there's no more callers on the line.
Okay. I think Ms. Debbie Lerner had mentioned that she wanted to comment on this agenda item, but for whatever reason, we cannot connect with her. But the record is open for folks to submit written comments. So in case she wants to submit her comments, she should certainly welcome to do so. So why don't we entertain a motion whether to hold a closed session for this item?
So moved.
Motion? Second it? Okay. So it's moved and seconded. Let's again check. Mr. Moderator, can you check on the queue whether we have public comment on this now that we made a motion? I know, but I was
Thank you, Madam
supposed to
Chair.
make- I
There's
was
no more
supposed to have
callers on the
public
queue.
comment after the action. Okay, so public comment on this one is closed. Let's call for a roll call, please.
I will now call roll. Commissioner Bush, Commissioner Bush,
Bush,
Aye.
Commissioner Flores-Fang,
Aye.
Commissioner Finliff,
Aye.
Chair Lee,
Aye.
Commissioner Romano.
Aye.
With 5 votes affirmative and 0 votes opposed, the motion is approved unanimously.
Now we will move into closed session. For update with labor negotiator, labor negotiations and status of meet and confer concerning the Ethics Commission's proposed November 2022 ballot measure and regulation amendments. And regarding the employee organization, San Francisco Municipal Executive Association representatives. For our public members who are watching online, the online screen notice stating the commission is meeting in closed session will remain on for the duration of our closed session. The audio and visuals will resume live once we reconvene in open session. We want to thank you for your patience and understandings while we convene into closed session. Do we need a 5-minute break? I don't. Okay.
I don't.
SF TV, San Francisco Government Television. SF TV, San Francisco Government Television. SF TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
on agenda item number 10. Do I have a motion not to disclose?
So moved.
Seconded? Okay. Moved and seconded not to disclose the closed session. Do we have a vote?
On the motion to not disclose closed session deliberations, I will now call the roll. Commissioner Flores-Feng?
Aye.
Commissioner Finlev?
Aye.
Chair Lee?
Aye.
Commissioner Romano?
Aye.
And just for the record, if I might clarify, Commissioner Bush had an excused absence. He's not at the meeting the rest of the meeting today.
With 4 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Okay. Let's go back to agenda item number 7, which is staff's recommendation to schedule an additional meeting before the next scheduled meeting for August 4th. Any discussions?
Chair Lee, if I may interrupt, there's a technical issue with the volume, or actually the audio online isn't available just yet. Chair Lee, I believe it's working now.
We still have an outstanding matter for agenda item number 7, which is a presentation, discussion, and possible action on proposed Ethics Commission ordinance for November 2022 ballot and amended Ethics Commission regulations to strengthen gifts and other city ethics laws. Before we entertain any possible motion on a possible action, we proceeded to closed session discussion with the labor negotiator. So we were going to pick up on any possible action to schedule an additional meeting before our regular scheduled August meeting. So do we have a motion?
Here's my motion. This is on the question about whether we're having a special meeting. I say that so there's 2 possible items to discuss in the special meeting. We'll talk about the second item on the behested payments.
Right now, we're only talking about the ballot.
I say that we should only convene about the ballot measure if, prior to that meeting, DHR has decided that we're closed. Is that the proper terminology?
See with the open session to discuss the possibility of placing.
No. If the negotiations are closed.
Makes sense to me.
Yeah.
Oh, you're right. Sorry, I think before we get to any of that, we have to address the closed session.
I thought we did. My
I thought we did too.
apologies.
Oh, okay.
We voted on that.
Yeah.
Oh, we did.
So
Okay,
we would
sorry
have-
about
You
that.
voted
Sorry.
for it.
Yeah, okay, I did. I voted for it.
Yeah.
Okay, good.
Great. I understand what you're saying. I'm with you so far.
Okay, so that's it.
So is that,
So we only, if we need to meet on the other issue, we can discuss that next.
Yeah, so I think the motion would be to have a special meeting if, at that point, we are legally able to proceed with the measure.
Well, no, yeah, sure, but go-
I assume staff can inform the chair if that action is possible, and then if so, the chair will schedule the item in the next meeting.
so why don't we just, we actually don't need to have a vote. We can just schedule a meeting. Okay.
Yeah, if
So why don't
that's,
we,
if, yeah. I don't, unless any commissioners have any objections, it seems pretty clear what the direction is.
so let's, I'll take back the proposal. We don't need to have a motion.
great, and I don't think that we should meet.
Because we're going to have a agenda item number 8 coming up. That also would require.
We should not meet and we should not discuss the ballot measure at a special meeting.
Unless the staff.
And no, unless the DHR, I really kind of, it's on them. Unless
the
DHR
staff
is,
tells us, yeah.
Yeah, just caution.
Yes, we, yeah. So Okay, so let's proceed to agenda item number 8, which is presentation, discussion, and possible action on implementation of city behested payment rules enacted in December 2021 and recent legislative developments. Mr. Kenning. Presentation, please.
Yes, thank you, Charlie. It looks like I've lost my share content ability. Caesar, someone on Edda, can I get that back? Thank you. I believe my screen is being shared.
Not.
Your voice is.
As the screen's not coming through?
Yep, I see it now.
Okay, great. Thank you, Madam Chair. Thank you, Commissioners. Wanted to give an update on the implementation of the behested payments rules enacted last December and some of the recent legislative updates. To recap, this is the same slide as was in item 7, except for now we're talking about the behested payments rules that were passed by the board in December and went into effect in January, but still part of the same larger government ethics and conflict of interest review project. So quick timeline of the some of the key moments in the behested payments rules. The Government Ethics and Conflict of Interest Review Project started in September of 2020. Also in September of 2020, the Controller's Office published a report recommending that the city reform the behested payments rules, including prohibiting city officials from soliciting behested payments from interested parties. In November, the Ethics Commission produced its report on behested payments that also recommended city officials be prohibited from soliciting behested payments from interested parties, as well as expanding the definition of what constitutes an interested party. In December of last year, the Board of Supervisors passed legislation that enacted those recommendations. And in January of this year, those rules took effect in San Francisco. The rules in question include prohibiting the direct or indirect solicitation of behested payments from interested parties by elected officials, department heads, members of boards and commissions, and Form 700 filers in the city, as well as an expanded definition of interested party to include city contractors who are not previously covered by the definition, as well as persons seeking to influence city officials, employees, and then registered lobbyists, as well as permit consultants. The rules also eliminated the previous behested payment disclosure filing that had been required, as the items that were previously disclosed would now be prohibited, so the disclosure would be unnecessary. Since being enacted, staff have received feedback and engaged in multiple communications with offices of members of the Board of Supervisors, department heads, and the mayor's office about the behested payment provisions. And here's a breakdown of some of the guidance shared by the commission, as well as some of the communications around behested payments that have taken place since the rules were enacted. When the new rules went into effect in January, the commission distributed a legislative update on the new rules. And then there's also some city attorney advice in January that was publicly available, or published to the Airport Commission and the Public Utilities Commission regarding the impacts of the new rules. An additional public notice was shared by the commission in March regarding the new rules. And I believe around April, communication between commission staff and the SFPUC started regarding how the behested payment rules were impacting the PUC's social impact program, or SIP. Throughout this process, since January, the commission staff have received 8 requests for informal advice. All 8 of those requests have been answered. The bulk of those have been received prior to the end to late April. So only 1 was received earlier. 7 out of the 8 were received since the end of April. On May 16th, the mayor sent a letter directing department heads and their CFOs to pause any solicitations or requests for philanthropic funding of any departmental programs or projects. And there was a public memo sent by the director of the Department of Children, Youth, and Their Families, which notified the public as well as funders that certain fundraising regarding the Summer Together initiative would not be able to be permitted under the behested payments rules. Within 2 weeks of that memo going out, a second memo was sent by the director of that department, clarifying that based on advice received from the city attorney's office and the ethics commission, that that fundraising was permissible under the behested payments rules. Lastly, on June 2nd, the mayor sent a letter to the Ethics Commission and the City Attorney's Office. This letter contained 48 questions regarding the application of the behested payments laws based on questions that the mayor's office says they were receiving from department heads as well as hypothetical situations. And on June 15th, the City Attorney's Office issued responses that were prepared in consultation with Ethics Commission staff that responded to 19 of the 48 questions posed. And yeah, all this has been part of a process that staff have been engaged in, meeting with the stakeholders to identify areas in need of revision or clarification to the behested payments rules that either could take the form of legislation or regulatory changes. And this list is an example of those efforts that we see as ongoing. Last month, Proposition E was passed with 69% of the vote. Prop E did two things. First, it prevented members of the Board of Supervisors from seeking behested payments from city contractors if the board had approved their contract. Second, it required future legislative amendments to be passed by both a supermajority of the Board of Supervisors and a simple majority of the Ethics Commission. And the passage of Prop E segues into the Commission's potential role in the legislation that's currently being considered regarding behested payments. There are essentially two pieces of legislation, one introduced by the Board of Supervisors and another proposed by the mayor. Both of these, now with the passage of Prop E, would require approval of the Ethics Commission to be passed legislatively. However, the mayor has also submitted a version of her legislation as a ballot measure that is scheduled to appear on the November ballot, and the mayor has until the August 5th deadline to potentially withdraw or modify that ballot measure. The recommended action the Commission is proposing to continue to pursue strong and effective behested payments rules. Staff recommends that the Commission continue to provide timely and thorough and responsive advice requests for advice and continue to provide guidance. Continue to work with the City Attorney's Office to ensure timely, clear, and consistent advice for city officials and employees who are subject to regulation under this new law. That Commission staff analyze the legislative proposals presented and continue to engage with stakeholders to identify areas for potential revision and clarification to these rules, either through legislation or regulation, utilizing the Commission's new rule established with the passage of Prop E. The fourth recommendation is to have the Commission call a special meeting for late July to consider the legislative approaches in more depth and be able to provide recommendations on those proposals so that the Commission can potentially act prior to the August 5th deadline if desired. And with that, I'm happy to take questions.
Thank you, Mr. Canning, for that. I have just a mechanical question. I guess the hope is that we'll pass legislation and then the mayor will withdraw her ballot measure. Is that right?
That is one potential. I think the other alternative there is that if legislative action isn't taken before the August 5th deadline, anything, it would kind of pause the ability to make legislative changes if there was something on the ballot, because come November it would get overwritten. So it would take more time to potentially make changes. But essentially, yes, that I think would be the benefit to acting before August 5th is that some of the concerns addressed in the mayor's legislation would be addressed elsewhere, and the ballot measure would not be necessary.
Wait, so thank you. So for that second point, I think you're saying that if we do pass something and then the board passes it, but the mayor's measure remains on the ballot, that would override whatever we and the board do anyways. Is that right?
I would
Yes.
confer with Deputy Attorney Chen, but that's my understanding that passing legislation next month would potentially then be overwritten by whatever is in the version on the November ballot.
Great, thank you. Yeah, these are just kind of timing questions. And then related to that, if we as a commission pass something, then the Board of Supervisors would still have to pass it, right? Because it goes through us first and then to them. So then there's that short window where between whatever we might do and the board does, all has to happen before, or not has to, but ideally would happen before August 5th. Is that right?
Correct. It would have to be passed by both the board and the commission.
All right, so that seems like a short timeline, but thank you, that's good for me to understand. In terms of just the substance, it'd be helpful if you could help shed a light on just some of what the callers brought up in public comment. And I know that you haven't had time to think about this, but you understand these issues better than I do, and so I think it might be helpful if you have some thoughts. For example, Mr. Cox from Tipping Point.
Excuse me, Commissioner Finlev. Sorry, I did just want to respond to one of your earlier questions. Sorry for interrupting.
No, it's okay.
About how sort of these potential legislative proposals and ballot measures would sort of interact. I think it would depend on eventually, obviously, what the language would actually be proposed. I'm not sure if the potential legislation at the ballot measure would actually be in direct conflict. I think we'd have to see. And then we'll sort of have to decide from there.
Right, that's a good point.
So it's not necessarily an all or nothing thing.
If there's no conflict, they could coexist, the legislation and the ballot measure.
Certainly, yes. If there's legislation and then the subsequent ballot measure and the subsequent ballot measure doesn't conflict, then it's certainly possible both would just simply be part of the code.
Before we have substantive conversation just on the timing, I don't know, maybe I should know this or somebody else knows this. What is the timing on the Board of Supervisors, assuming that we approve the bill language? Does the Board of Supervisors regularly meet to vote on legislation? Do they have?
Yes, the board generally meets on Tuesdays. Their last meeting before the August recess is scheduled for July 26th. And then in terms of the mayor's proposed initiative ordinance, her potential deadline to withdraw that measure is Friday, August 5th.
So just to clarify then, is it correct that we would, in order to do this all before, our timeline is being pressed again by this August 5th deadline, but in order to get the work done before August 5th, we would need to sign off on any legislation prior to July 26th. Is that correct?
You may actually want, I believe we have someone from the mayor's office who's available to speak. I don't want to speak for them in terms of their legislative strategy.
I'm not talking about strategy, I just want to know schedule.
Right. So, I mean, in short, no final legislation is going to be passed by the board by July 26th or August 5th. There's just not enough time.
All right, so.
And I think why they are asking for you to consider it today is to get a signal or sense of where the ethics committee lies on these issues and these proposals.
I see, that is good information.
But again, I don't want to speak for the mayor's office or some representative supervisor's offices who may be on the line.
And they'll, I'm sure, weigh in when they add public comment. But I'm wondering whether, is there any requirement that the Ethics Commission review the legislation before the board, or the order doesn't matter, right? It has to go through both bodies.
Right, so it does, so under the recent June measure that addressed behested payments, I believe the Ethics Commission would need to go first.
Other timing process questions?
So I guess I do have a question. I mean, is it possible for us to kind of get this revised and on the ballot by August 5th, is what you're saying? Because there's no time for what we decide to then go to the supervisor.
So to clarify, we're not being asked to revise anything. The mayor can put her proposal on the ballot regardless of anything that we do. There's a question about whether or not she might withdraw her ballot proposal, which she would need to do before August 5th.
But why would she withdraw?
She would withdraw if if they would go through the ordinary legislative process, which we would need to approve.
Right, which is what I'm asking. where
Right,
it's
but
like-
which Andrew just said there's no chance that it would happen before August 5th.
Okay.
Right. Again, I don't want to speculate as to what their legislative strategy is. They are likely available if you want to speak to them. You do not need to wait for public comment to hear from the mayor's office's representatives, to be clear.
So I know that they called in earlier. So can we see if they're...
Mr. Moderator, can you see if they're in the queue?
And also, out of fairness, I think we should hear from the board also, because they also submitted a letter. So if we can have both representatives from the mayor's office as well as the board of supervisors, just to clarify where things are.
We understand, Shirley, we understand that the mayor's office representative is on the WebEx meeting, and he's more than happy to speak at this time if that would be useful to the
So let's
commission.
call on him first. And then if you can reach out to the board of supervisors to see if anyone would want to call in to walk through what they're doing as well.
Chair, I'm putting Mr. Heckler on the line.
Okay. Please go ahead.
Mr. Heckle?
Does IT need to unmute the
Can you hear me?
Yes.
Yes. Please proceed.
Can you hear me?
Yes.
Oh, you can hear me. Thank you. Good afternoon, commissioners, Director Pellin, members of the staff. I'm Hank Heckel, compliance officer in Mayor Breed's office. Happy to address any questions you have on the process.
Mr. Heckel, we are on agenda item number 8, which is a discussion on the city's behested payment rules. And it was brought up that the mayor is currently planning to put a ballot measure on the November ballot. And you're very interested to know what the commission's possible action in this area is. So can you share with us where things are with the mayor's proposal and what's in it so that we can have a better understanding going forward?
Before we get to the substance, I would really prefer some guidance on the timing and why we're being asked to do this at special sessions. Can you speak to that?
Yes, can you hear me?
Yes.
Okay, thank you, Commissioner Romano and Chair Lee. So as was addressed before in public comment, we believe there are a number of substantive sort of problematic consequences to the legislation, and we've proposed a number of amendments to deal with those. I understand you'd like to hear about the timing first, so I'll touch on that. As was said, pursuant to Prop E, before any amendments can occur legislatively, they have to go through the Ethics Commission and receive approval from a majority of the commission. And following that, the Board of Supervisors may approve the amendments by a supermajority vote. We have been working with department staff extensively across various departments for several months and hearing feedback and trying to understand the application of the legislation to various public-private partnerships and key programs that are funded by philanthropic dollars, which account for millions of dollars in funding for important city programs, and that includes money that goes both directly to city departments and money that goes to community partner nonprofit organizations. There's been a need to get that feedback and also pose questions to the Ethics Commission and the City Attorney's Office to understand where there might be some unintended consequences and pitfalls in the legislation so that we could work out some legislative fixes. So unfortunately, that process has taken some time, and we do kind of find ourselves now, at this stage where we would like to resolve these problems. We've proposed the legislation to the board. We've proposed a ballot measure that mirrors those amendments. Ideally, we would prefer to address these issues legislatively, and so we would ask that the commission look at the substance of our amendments, and I'm happy to sort of discuss that substance and address questions. But given the timeline, if there's action on amendments that we feel resolve the issues, we'd certainly be in a position then to withdraw the measure before the deadline.
Wait, if I may?
But first of all, I just want to make clear that the request for an additional meeting or special meeting was made by the staff, given the issue that's come up. So it wasn't requested by the mayor's office or anybody. So am I understanding this correctly?
Yeah, our staff memo recommended a subsequent meeting this month in order for the commission to dig further as it wishes into the proposals.
Yeah.
The mayor's office and Mr. Peskin's office were aware of that, and so the communications they're responding to is saying that they believe apparently that it would be useful for the commission to engage again before the August 5th deadline for the purposes that I believe they're describing.
Right, okay.
So they didn't ask for this?
I believe our memo was out in circulation, and they're responding to that.
Okay.
I think it's really important to...
I would say that it was not, I'm not sure if Michael or if we were on staff aware that there was no chance that the legislation at the Board of Supervisors would be moving by July 26th. If that were the case, then that certainly seems to put a different cast on the urgency of the commission's meeting this month. So I would just point that out.
So
may I briefly respond to that? Oh, sorry.
Yeah, if you would, really on the timing. I understand that there's been some issues, that there are issues that you guys want to address. I understand that a lot of work has gone into it. I really do want to understand the timing vis-a-vis why the commission should meet and vote on this expeditiously.
Well, I mean, I think there is a feeling of urgency among departments because, as was referenced, the mayor issued a letter a couple months ago now issuing all departments to pause any program that relies on philanthropic support so that we could vet compliance, because the mayor wants to comply with the law. We want to ensure that all staff comply with the law across departments. This is legislation that poses personal liability and on staff and puts them in jeopardy. If they violate this law, they could be fined, up to $5,000. And, the mayor takes these requirements very seriously, and so we want to be very careful about proceeding with any of these programs. But because of that, there are a number of programs that are paused, and we've sought guidance from the city attorney. That's taken some time, understandably. We've sought guidance from the Ethics Commission, and we've received that, but we haven't received answers to all of our questions yet. And we believe that our legislation will resolve these issues. So that's kind of the background on the overall sense of urgency. With respect to the process right now, I understand that even if the Ethics Commission approves the amendments, the Board of Supervisors likely would not be able to act prior to August 5th. However, I can't sort of commit to anything at this point, but it would appear to us that if the Ethics Commission sort of moves in a direction that helps to address these problems and approves amendments that I think are effective to address these problems, I think there would be an understanding that the Board of Supervisors could act later. They could act in September, but in the meantime, the need for the ballot measure would be obviated. So I think whatever action the Ethics Commission takes is really going to be an important step, and it's not binding on the Board of Supervisors, but I think it would certainly be instructive to the board, and the board, I think there would be a very good chance that they would adopt the amendments that the Ethics Commission adopted.
Thank you.
I have a question for Deputy City Attorney Shen. I seem to recall you mentioned once ballot measure is placed, you can also withdraw it. at a later date, right? So that's even if the mayor decides to put on a ballot measure without any input from this commission, ultimately before November or before a certain date.
Before August 5th.
August 5th, it's the same deadline.
So she has placed it on the ballot.
But once she places it on the ballot, she cannot withdraw.
She can withdraw up until August 5th. So as of now, and I know it's a bit complicated because the mayor has submitted essentially three different ways the same legislation. One of those three ways is a ballot measure that, as of now, is currently on the November ballot. She can withdraw that up any time until Friday, August 5th.
A question for the mayor's representative. I think it was Mr. Heckled. I hope I'm not saying your name wrong.
No, that's right. Thank you.
Thank you. I understand that if we, the Ethics Commission, pass legislation that is the mayor's version, then she might withdraw her ballot measure. But what if we pass the legislation that's sponsored by Supervisor Peskin, which to me seems, I'm not prejudging the merits, but the two legislations seem very far apart. So I would assume that if we pass Mr. Peskin's measure, I'm not sure the mayor would then withdraw her ballot measure because they're so far apart. I guess that's my question.
Yeah, thank you, Commissioner Finlev. Yeah, I mean, I don't know that I would agree that they're far apart. I mean, we've reviewed Supervisor Peskin's legislation. We are in contact with Supervisor Peskin and his staff. I mean, obviously, I won't speak for them, but I think that there actually is a lot of overlap between the two versions. Our amendments just do a bit more. So, we do some of the same things, and then we do a bit more. For example, we think that the best way to deal with this issue of confusion over the attempt to influence is just to remove that prong from the legislation because, there are still the other prongs that cover contractors and administrative proceedings and lobbyists and so on. And we go a little bit further in narrowing the administrative proceedings prong to limit it to prohibiting solicitations from people that were actually involved in the administrative proceedings, so that you don't have, Rec Park having 100,000 picnic table permits issued, and then every person who received that permit is an interested party as to every single person, every single Form 700 filer in Rec Park. And we also have some broader exceptions that would allow for behested payments to go directly to a city department because those are subject to accept and expend requirements that where the board has to approve those payments. So the board would have oversight into those payments, and there would be accountability and transparency. So I don't think we're in a position to commit to anything at this point. I don't know that it's a binary choice. I mean, of course, we endorse our amendments, and I can sort of explain them in more detail. But there could be some other approach where different elements of each set of amendments are adopted. We'd be willing to look at that. If Supervisor Peskin's amendments were adopted over ours, I'm not quite sure what the action would be at this point in terms of the ballot measure. But I understand your point. I mean, obviously we prefer the amendments that the mayor's proposed. I believe there are some supervisors on the board that would endorse them as well. And we would be in a position to withdraw the measure if they're accepted. Whereas if Supervisor Peskin's amendments or some kind of third version were implemented, we'd kind of have to take a look at that.
Thank you. I have a process question that Mr. Heckel can take a shot at, and then maybe Deputy City Attorney Shen. But I'm curious if we pass some version of one of these amendments, and then does the board just do an up or down vote on it? Or if they then make amendments, does it come back to us? And then if we make amendments, it goes back to them. So it could be a back and forth process ad nauseum. I'm looking at Mr. Shen, but I think I said Mr. Heckled first, but I'm getting the sense that what I said is correct.
Since both bodies essentially need to approve the amendments, it is possible to have sort of this ping pong effect where ethics approves something, the board tweaks it, has to come back to ethics for further approval, et cetera. We have done that of other legislative proposals that do require both bodies to approve them. It's something that we've dealt with in the past. It has worked out. It does take a little time.
Thank you.
So follow up to our Deputy City Attorney. So for the Board of Supervisors, they would need a supermajority vote. Do we need to have a supermajority vote or just a simple majority vote from this commission?
A simple majority, and then they would need to approve it by a supermajority, as you said, Chair.
Okay, okay.
I'd love to hear from someone from the board if they're on the.
Yeah, Commissioner, we've reached out to Supervisor Peskin's office, have not heard back yet whether or not someone's available to come speak.
All right, I have some questions on the substance as long as, I'm sorry, the representative from the mayor's office, I didn't catch your name.
Yes, it's Hank Hackle.
Hackle. Thank you, Mr. Hackle. I, unfortunately, am not super familiar with the measure. We were provided a memo from our staff which quotes a summary of the mayor's proposal. I'm not sure where that quotation is from, but I presume it's some sort of legislative summary. Are you familiar? Mr. Canning, are you on the line?
Yes, that's from the ordinance proposed by the mayor.
Right, and just that summary, the 1, 2, 3, 4, 5, 6, those, that's,
Yeah.
okay.
The full measure is in the packet.
I understand, I haven't read it, that's what I'm trying to say. Mr. Hackle, with regard to, are you familiar with what the 6 points in the, I guess it's the summary of the measure?
Yes, I am.
All right. I sort of questions about points 2, 3, and 6. 2 is about interested parties who are issued ministerial licenses or permits. Is there a definition of ministerial, or what is that? That seems, yeah, what is
that? Yes, thanks, Commissioner Romano. So, yeah, I mean, this concept has come up a lot, and there is a definition in the amendments which kind of refers to, it's basically carving out ministerial permits, which are kind of considered like over-the-counter type permits that don't involve kind of discretionary review or a substantive back and forth between the applicant and the department. So I think the, sort of classic example would be like the picnic table permit. Although again, in certain cases, like some things that begin as ministerial could become substantive if there is some kind of discretionary review that becomes necessary. But
got it.
Something in the nature of a form is filled out and submitted, and you kind of check the boxes, and then you get your permit.
Got it. That makes sense. Point 3, a person does not become an interested party by attempting to influence legislation. Is that correct?
Right.
Why
So,
do we have that exception?
Yeah. So thanks for raising this issue. I think this is this is probably the most challenging aspect of the legislation for departments to kind of wrap their heads around and deal with, because it's quite broad. We think it's a little bit vague, and it sort of covers communications that are just very much sort of part of the normal political process, where you have an advocacy group, that meets with members of the Board of Supervisors to advocate for a particular policy or a new piece of legislation, and then later on in some unrelated context, or maybe even in a related context, they are then, those officials are then barred from engaging those advocacy groups, which are oftentimes philanthropic foundations, in providing funding for a project. And I'll give you a concrete example. So one of the questions we submitted to the city attorney's office, and I think it was covered by the representative of the Department of Homelessness earlier, it involved the organization Tipping Point. A representative from Tipping Point provided public comment earlier as well. And in the program, a program that went into effect with support of Tipping Point was this cabin shelter pilot program at 33 Goff. It was a bit of a policy innovation where there's essentially these tiny homes that are used to shelter homeless individuals. And that's something that Tipping Point has advocated for as a positive policy solution to homelessness. And so they had meetings with officials in the Department of Homelessness to advocate for such a policy. And because of that advocacy under the legislation, they would be barred, the HSH officials would then be barred from soliciting funding from Tipping Point to another nonprofit to actually implement the program. So it's kind of becomes this self-defeating situation where...
Say that again. They'd be barred from, say that again, from...
So the HSH officials who had previously met with Tipping Point,
Correct.
or a similar organization that advocates for a policy initiative, they then that is an attempt to influence under the current legislation.
Right, I understand. They would be barred from what?
So then they would be barred for returning to Tipping Point to say, we agree, this is a good program. Can you fund this nonprofit that's going to implement the program? They would be barred from doing that.
That seems precisely the point of prohibiting behested payments, right? Is that somebody comes to the city and says, we support this policy, right? That's what Tipping Point is doing. And then the city turning around and saying, yeah, we like it. Actually, Tipping Point, why don't you give some money to this other nonprofit? That seems precisely what the behested payment rule is trying to prohibit.
I mean, respectfully, I don't know if I agree with that. The intent of the legislation is to get at pay-to-play corruption. So, I mean, this is a program where the party that's engaging in the advocacy is also a funder. So they're saying this is a pilot program, this is a novel program. And those types of programs tend to rely on outside money because they're new and they're novel. And so maybe the city doesn't want to pay for it, but the city will say, you know, we will try this on a trial basis because this organization is going to pay for it. But if you can't talk about them and coordinate on the project and kind of listen to their advocacy about it, you're not going to be able to implement these types of novel
and does your
policy innovations.
Does the mayor's proposal of saying that no one becomes an interested party by attempting to influence legislation apply only to new and novel projects, or does it apply to everything?
No, it applies to everything, but we would, of course, leave in place the contractor prohibition, the administrative proceedings prohibition, the lobbyists, the permit consultants, which I think get at, you know, the type of maybe commercial or sort of things that are perceived as quid pro quo. You know, those would still be barred pursuant to these other prongs. It's just the attempt to influence prong is so somewhat nebulous and also creates this catch-22 situation where when you're trying to deal with, you know, foundations that kind of do advocacy and also fund the results of those, you know, they fund projects that are consistent with their advocacy, which are could be pilot programs.
All right.
Can I ask a question on this very point before you move on? Mr. Heckel, this specific example is super helpful to kind of conceptualize what's going on. In your example, what if, does it matter who does the soliciting? So what if, in your example, Tipping Point and the city meet, discuss the program, and then Tipping Point comes back and says, great, where do we send the money? As opposed to the city going to Tipping Point and saying, send the money over here. Does that, in your understanding, affect whether or not any subsequent payment would be behested? In other words, if it's at Tipping Point's own behest, they're just asking the city where to direct it.
They're not liable under this.
Does that change the analysis?
Wait.
Sorry, go ahead.
Yeah, if I may. So, on the question of liability, the city officials are the one bearing liability. But in your example, Commissioner Finlev, my understanding is that, you know, if they come back to you and say, where do we send the money? And you say, you know, we found this nonprofit that can build these tiny cabin shelters, and you know, those are the types of partners that implement these programs. Often the city does it in partnership with other community organizations. So by directing the funds, that's a solicitation. So even if you don't say, give us, you know, we think we would need $1 million to do this, if they come back themselves and offer the money, but you direct it, because the definition of a behested payment is very broad. It's coordinating, directing, suggesting. So really any type of engagement on the providing of the funds for the city program becomes a behested payment. And if they have this prior advocacy relationship to you, they're an interested party, and then you can't actually make good on this policy collaboration.
Got it. And I'm not judging the merits or taking your side necessarily, but I want to understand the point. I think your point is that if the, for example, tipping point can't engage with the city, it won't know where to most effectively direct the resources. Is that the concern?
Yeah, that's precisely it. I mean, it's, we don't want money just sort of, it's not useful to anyone, to needy recipients of these types of programs, just to have the money sort of, and the funding, be sort of blindly thrown around, right, without coordination with the city departments that are on the ground, that deal with homelessness, that know where the needs are. And this idea of getting grants from foundations and philanthropists is quite common and accounts for millions of dollars for various important city projects. And if you can't sort of coordinate with them, it really inhibits the projects. It makes it extremely difficult to implement. And I just want to say one thing in clarification too, because there's been some questions around where you can coordinate on these grants. When the grant's going to these third parties that are nonprofit partners, that's where we run into this problem. And so anyway, we think that removing that prong would ameliorate these concerns, and you would still have the protections of the other interested party categories.
Can you describe what kind of behested payment would be prohibited under if the mayor's proposal were to pass? Would be prohibited that wasn't prohibited under the law prior to Prop E?
If our amendments don't pass?
If your amendment does pass, what is left? I'm asking what is left of the behested payment rule in Prop E?
I see your point. Oh, yeah. I mean, I would say there are tons and tons.
No, I'm particularly about this kind of situation. What kind of behested payments are prohibited?
So a behested payment from a contractor would be prohibited. A behested payment from someone.
Can you give a kind of example from a contract, a behested payment?
Yeah. So I mean, a behested payment from, let's say the airport has a vendor that leases space from them.
Right.
They could go to the vendor and say, we want you to fund some new improvement to the airport that's kind of unrelated to that lease agreement.
So that was prohibited. That was permissible prior to Prop E.
It was permissible. It was permissible prior to the behested payments legislation that went into effect in January. Prop E didn't really change.
Right. I'm sorry. The behested payment is right, and it would be prohibited now. It's prohibited now because they're a contractor. But what if they were attempting to influence administrative action by getting their contract? So aren't they exempted?
Well, so the contractor prong is broad enough that it covers existing contracts, but also those seeking a contract. So if they're seeking a contract, that's covered by the contractor prong, and we don't want to change that.
That's considered not considered an administrative action, I guess.
Well, it might be, but it's covered because they're already seeking a contract. So the contractor prong, we would leave that intact, so that it's the case now that if you're seeking a contract, you're an interested party, and it would continue to be the case under our amendments.
All right. Moving to another prong. Does anybody have any questions about this? Excuse me? Yeah. Number 6, it exempts parties to development agreements from what? Can you explain what's going on there?
Yeah. So this is kind of related to. So there was a program that the PUC had for many years called the Social Impact Program, where the PUC worked with contractors, in the context of issuing contracts in the RFP process. The contractors would provide community benefits to different charitable needs or nonprofits, and perhaps related to the contract itself. And under the behested payment legislation, as was set forth in a memo from the city attorney's office, that whole program had to stop because they were an interested party by virtue of being contractors. Now, the community benefits are a little bit distinct because it's essentially something that is it's commonly sort of bargained for in the contract for, if you had some kind of development project, the city often works with the contractor so that they give back to the community, maybe in the area that's going to be impacted by the development. If you're going to put some new building in, that you would provide community benefits and services kind of in the surrounding area. And so, because those are important programs, and because it's sort of part of a transparent bargaining process, and it's giving back to the community, we would want that to remain intact with the amendments. So and there's a version of that in Supervisor Peskin's amendments that is a little bit different than ours, but it's kind of getting to the same place.
But again, so somebody who has a development agreement, I assume that that's defined.
I'm not sure a development agreement is a defined term. I'd have to go back and look at the ordinance again.
Okay, so the city official could go to the person who's in any development project and say, could you please give to this other organization?
Well, if it's part of the bargained for exchange in the contract. So it's not something that's sort of outside of the contractual bargaining itself. It's something that's kind of in the context, maybe in the RFP, or it's discussed in the context of the contract that the particular developer or other contractor would provide benefits back to the community that's impacted by the project.
So it has to be it's only contracted behested payments, in other words.
Yes, that it's sort of bargained for exchange.
And to be practical, is this the kind of situation where developer builds, a big building and agrees as part of that to also build a community center for the neighborhood, something like that?
Yeah, that's exactly right.
Which that example seems totally fine and something that we would want to encourage. What we obviously would not want is somebody wants to build a building and whoever's in charge of issuing the permits says, can you please give to my favorite nonprofit organization?
Yes, I think we agree with that.
And the second example remains prohibited?
Yes.
Thanks. I have no further questions.
Do we have a representative from the supervisor's office online?
I'm sure I don't believe there's a representative on, but I could respond briefly to some of the items brought up if desire.
Okay. Before you proceed, I'm uncomfortable to move forward on this without input from the Board of Supervisors, because we have two compete. Well, even though they have a lot of similarities, but they're two different proposals. And out of fairness, if we do not hear from Supervisor Peskin's office, despite all the attempts.
Wait, Madam Chair, I don't think anyone's considering voting on any of these measures today. Even if we heard from the supervisors, I would not want to do that.
Okay, I just want to make sure that, we're not going to take any action without.
The only action that we would take is to agree to meet on the
separate meeting.
Special meeting.
Just wanted to make sure. Okay, Mr. Kenny?
Yeah, thank you, Madam Chair. Just wanted to add a little bit of context. I think the purpose of recommending a special meeting would be to be able to have a more in-depth discussion on the substance. But I think that in general, staff agrees that there are areas where the behested payments rules could be reformed and clarified and improved, and I think we've been having those conversations in preparation of being able to bring that before the commission to discuss those. To a couple of the specific ones discussed by Mr. Heckel, I think there are definitely ways to reform the attempt to influence prong that don't necessarily involve throwing out the entire prong. And to some of the hypotheticals that were discussed, I just wanted to clarify that the attempt to influence prong only makes someone an interested party for the individual city officials that they have attempted to influence. So if someone, was attempted to, or if a non-city entity was attempting to influence a city official on a policy matter, that would not prohibit everyone in that department from potentially soliciting a payment from that individual, just the city official who was attempted to influence. Clarification. And, to the issue with the SFPUC's ZIP program, I think we've had a good conversation with their staff. I don't know if they are on the call, but they definitely are interested in making a more in-depth presentation to the commission. There have been many issues identified with the SIP program. The controller issued a lengthy report on that program and some of the issues with transparency and decision-making processes. From what we've heard from the PUC, they've taken actions to resolve a lot of those concerns. But I think that would be something that would be valuable for the commission to hear about what those reforms have been. I think with that program, one of the elements is just thinking about, how does that list of nonprofits that are acceptable, how does that get decided who's on that and who can be participating? I think that's the potential concern there. And then a lot of these other issues, I think, there's a shared interest. For example, with exempting ministerial permits, that's something that I think a upcoming staff report would probably recommend the commission consider doing, is having that ministerial exception. That's also something that could be done through regulation too, that doesn't necessarily even require a legislative solution. But I think ultimately it's a timeline or a issue of timing on this issue, and the commission does have a process that would involve issuing a staff report on these proposals and potentially holding interested persons meetings to hear more directly from stakeholders. I think we've heard a lot about engagement with the mayor's office, but have heard less from departments directly, and I think it would be beneficial to have a process where those departments could raise those concerns in a more public, transparent way as well.
Yeah, thank you. And on that last point, is there anything, aside from the interested persons meetings that you've had, anything that you've found productive to kind of invite city departments to reach out more proactively? Because it seems like the turnaround time between departments' requests and your responses have been pretty great. So just thinking about why maybe city departments haven't, are they waiting for us to issue more customized responses, and is that even feasible? Just things that I'm thinking about, because I also wonder if, from the questions that you've received, there are just a lot of common themes, which it sounds like there might be, and whether that means we should issue a revised or an amended or a supplemental FAQ that responds directly to those new points.
Definitely. As mentioned, there have been 8 requests for advice since the rules went into effect. And, at the kind of meta level, our process would be to, when the new rules in effect, if we're getting advice questions on those, is to take those and respond to those on a case-by-case basis. But that is not, by any means the end of the process. The process is to respond to the specific cases as they come up, and then move to recommend either legislative or regulatory changes based on what's coming out of those questions, specifically if it appears that it's a general issue that's being identified, or an issue that multiple people are asking about. Clarifying that would be sort of the next step, and that can, as you mentioned, take the form of revised FAQ or clarifying statement, or through more substantive regulations or legislation with the board.
May I comment on that point?
Please go ahead.
Thank you, Chair Lee. Yeah, in response to Commissioner Flores Feng's point about feedback and questions from departments, I do want to clarify the mayor's office has been working extensively with many departments over the past several months, and we compiled a lot of that feedback into a letter that the mayor sent to both the city attorney's office and the ethics commission that had 50 questions in it that were based on department feedback that were either real, sort of real world examples about their programs or hypotheticals that are sort of closely based on likely scenarios. And we have gotten very helpful responses to about half of those from the city attorney and the ethics commission. All of the answers were no, that you can't do these things. And I think it's good to get guidance. I think some of the guidance was troubling. There's some extreme examples in there that I would sort of invite the commissioners to. It's linked to the agenda, the city attorney's answers to our questions. There was a June 15th letter. It's mentioned in the agenda, and it's linked, and it has examples of how someone that seeks a permit for a birthday party and asks for a bouncy house for their kid's birthday party becomes an interested party to hundreds of Form 700 filers in Rec Park who had nothing to do with the permit. And so, those parties couldn't even ask these people for donations, for their own, for the March of Dimes for $100. If they, totally unbeknownst to them, their neighbor, they asked them for a donation. They happen to be one of the, thousands and thousands of permittees to their department. So those are answers to questions 21, 23, and 24 in the letter. The tipping point HSH example about the cabin pilot is question 6. There's a number of very illustrative examples in there, and we do look forward to receiving answers from the Ethics Commission and the City Attorney's Office to the remaining 30 or so questions. Thank you.
Okay, if there are no other comments from the commissioners, I think what's before us for a possible action item is whether to hold a additional meeting before August 5th, given the time sensitivity and also the information that we've received and also heard today. So why don't we see if there's a motion to have a meeting. But before we do, why don't we ask the executive director, given the room availabilities, if we're looking at any time between next week to the end of July, are there any potential availabilities that we should consider before we approve a new meeting? Because we need at least three members of the commission to vote.
Yes, there are. We have meeting room availability, we understand, on Monday, July 25th, and on Wednesday, July 27th, both in the morning from like 9 o'clock to 2. This room would be available at that time, but not prior. And I think, Madam Chair, we also have 2 more members of the public in the queue to provide remote public comment.
We're going to take the vote, and then we're going to open up for, no, not vote. We need to have a motion first before we open up for public comment for agenda item number 8. So do we have a motion?
Well, I think
to have an additional meeting before August 5th, then we'll open up for public comment for agenda item number 8.
I have a discussion point. It sounded like Mr. Koenig was describing a good amount of work that he would need to do in terms of IP meetings and outreach and analysis. And I think we should make sure from the staff that it's even realistic to do this, to have a productive meeting, because we're already tasking him with a significant amount of other work.
Yeah, this is on top of all the ballot measure.
Yeah. Well, his recommendation was to hold a additional meeting in July to further discuss agenda item number 8. And I think that I understand he needs to do a lot of the in-person meetings usually takes a couple of months just to prepare itself. So my understanding was, given the deadline that we're faced with, right, because of the potential of the mayor putting it in the ballot, that's why Mr. Canning had requested possible action, an additional meeting before August 5th, so that we can further discuss and take possible action.
Sorry to interrupt.
That was his recommendation.
My understanding, and please correct me if I'm wrong, was that the recommendation was to meet prior to meet the August 5th deadline. We're now hearing from most people that August 5th is not a real deadline, but it still remains a pressing problem for the city, which is why the mayor and the Board of Supervisors would like us to sign off as quickly as possible. So that's really the urgency. It's not the August 5th deadline.
The mayor is the August 5th deadline, right?
Well, I guess I heard that the mayor might withdraw her motion or her ballot measure by August 5th if we do something.
Yeah.
Which is kind of vague. Speaking just for me, obviously, I can be available for a special meeting, but I don't like having these deadlines forced on us, especially when there's no real specific concrete specific reason. There's a potential that the mayor will withdraw her measure, and I guess we can go forward on assumption that she might, but so I guess that's a long way of saying I'm available, but with some reservations about this process.
I want to say the second thing. Listen, this is this responsibility and authority for us to sign off on legislation is brand new. Obviously, the city, the mayor's office, Supervisor Peskin has been in negotiations with parties for months, and we're being asked to approve it in days, if not weeks, without much counsel from staff. Obviously, we don't want to be a rubber stamp. At the same time, we want to be good partners with the city, and we understand that there are pressing concerns about the legislation. So I join Commissioner Finlev's position that I am available. I don't want it to become practice. We have a regular meeting schedule, and for the most part, legislation should be presented to us on our regular monthly schedule.
Just for clarification, the issue of behested payment has been discussed at the before a majority of the members on this commission. So staff as well as the commission has been discussing behested payment for a long time. It was the Board of Supervisors' decision to take it, for them to place it on the ballot, because at that time there was a lot of discussions. But moving forward, I do agree that it is not a good practice to constantly have these additional meetings, but every additional meeting that we've had since I've been there has evolved around things out of our control, such as the ballot measures that's been delayed because of further delays caused by other folks. So I think that the staff has been working very diligently, not only on this behested payment. They've been in discussion and working with all parties on behalf of the commission. We could have placed the behested payment thing on the ballot, but the Board of Supervisors had taken it on, and now the mayor wanted to put her ballot measure, and we are working on the deadline because we do want to be good players, and it is a very uncomfortable place to be, but hopefully this would not be this would be the last. Well, I shouldn't even say it's the last. Never know. But why don't we take public comments on this and then we'll vote? So we do have a motion.
Madam Chair, may I speak to the workload item that was raised before in timeline?
Please.
Yeah, so I mean, I think the recommendation was to call a special meeting for later in July. I think the real benefit to that would be if it might influence the mayor's decision to leave her measure on the ballot. But it does sound like even if the commission were to meet on the the week of the 25th and come back with a revised version of the legislation or recommended suggestions, or even come back and just approve it, it sounds like there still might not be time for that action to be completed by the August 5th deadline. So given that legislative timeline, that reality, I do wonder how necessary it is to have that special meeting versus scheduling this item for discussion at the regular meeting in August, which would be after that deadline. I think the process that we would do regardless of, or if we didn't have this kind of ballot measure timeline consideration, would be to schedule interested persons meetings for later this month or early August to refine what the recommendations would be to pursue and bring potential regulations to clarify some of these questions that are outstanding. But yeah, I think it just really comes down to what impact, if any, commission action would have related to that deadline, because the feedback that would be able to be provided in essentially 2 weeks from now on the week of the 25th, we can definitely provide recommendations around the pieces of legislation that have been introduced and make recommendations to the commission based on those. But that would definitely be a more scaled down process that I think we would prefer to do if we didn't have that time constraint. Just wanted to state that.
Well, that's good to know.
May I respond?
Yes, please, Mr. Hackel.
Thank you, Chair Lee. Yeah, I just want to be clear and respectfully. I mean, we in the mayor's office do see benefit to another meeting before August 5th. I understand that's asking the commission to do something that's not necessarily very usual and have this additional meeting, and we appreciate the work, but the staff and the commission as partners in addressing these issues. But we do see value. I do think there is a potential path forward out of that meeting. I don't want to dismiss that. I mean, certainly if our amendments were adopted, right, there'd be sort of no reason to go forward with the ballot measure August 5th. But so that's a possibility. But there, as I said, there could be some further work and compromise that does lead to a result where the ballot measure is withdrawn. But that can't happen at all. That's guaranteed not to happen if there isn't at least a chance and an attempt to work on this more in an additional meeting before August 5th. So we would be in favor of that additional special meeting being held.
Mr. Kenny, since you're the one who made the recommendation that we take action to schedule an additional meeting, and also given the intense interest around this issue, because it was just voted on by nearly 70% of voters in San Francisco. So there's a lot of interest around this area. And the Ethics Commission is a central player on this matter. I do see the benefit of us having a more I shouldn't say informed, but a more a deeper dive into discussion between the two proposals. And if my colleagues agree to have an additional meeting in July so that we can have Mr. Hackel back again, as well as a representative from the Board of Supervisors, so that we can have a more meaningful engagement. And Mr. Hackel may be right. Maybe things turned out that the mayor would decide that she doesn't need to place a ballot measure for the November ballot. But if we can carve out a couple of hours for either the 25th or the 27th to have an additional meeting. Meanwhile, if Mr. Cannon can put together an interested party meeting, I'm sure Mr. Cox from Tipping Point would may want to help bring together some of the stakeholders that he was talking about, that we can have more information. And again, a reminder to my colleagues, these interested persons meetings, we can participate as long as there are not three of us, so that we can also get more information, so that we can have a really good, hopefully we can have a good product coming out from that meeting. So it's not just another few hours of talking about the same thing. So if we have the, since we have the motion and the second to have an additional meeting, let us not agree on the date, because I know I have a conflict on one of the days and I need to change, but do we want to have a open-ended
Shirley, may I
motion?
respond to that?
Oh, yes, please.
Yes, thank you. I think to your first points, I definitely agree. I think, calling a special meeting to further discuss these issues would be relevant, especially given Mr. Heckle's last comments. I think that would also give an opportunity to make sure that Supervisor Peskin or someone from the board or Peskin's office were able to also join in the discussion. And we can also hear more from the PUC during that meeting. And just additional stakeholders as well. I do think, given that condensed timeline, to try to have a special commission meeting the week of the 25th, it would be unrealistic to try to also do interested persons meetings in the same time. So I think it, should probably pursue a special meeting, but maybe hold off on doing IP meetings until, sometime in the future.
Okay. Why don't we do this? Let's settle on the 20. Can we just have an open-ended?
My recommendation is that if we know those two dates are available, if there is the commission is comfortable settling on one of them, I think that will help us set expectations for the public and others who might want to participate. You could select a date today and give us some indication of your preference.
Throwing it out there, the 25th is better for me. 27th is problematic.
The exact opposite. So choose between your two favorite.
No, I'm taking 27. 27 is better for me. Well, since it only takes 3 votes, right? So we don't have.
Yes, and I don't think it requires a vote. I think if you're just telling us your scheduling preference or your availability or you're reaching consensus on that, I think that's what we're looking for.
But just to make clear, this special meeting that we are contemplating holding is to have a pretty substantive up or down vote on each of the 2 legislative proposals.
And it does
And
not
we could propose,
require-
we could give thumbs up to both of them, correct, Mr. Chen?
I would have to double check they're entirely consistent, but yes, it certainly seems possible.
Okay, so why don't we settle on the 27th?
Also, to Commissioner Romano, to your point, a straight up or down vote on each of the pieces is not necessarily the only option. The commission, I believe, would also be able to, go in and recommend, changes to either of those versions on the substance as well. It's not a simple yay or nay.
I should take that back. The point of the meeting is to be good partners with the mayor and the board of supervisors, to show them that we are ready and willing to work with them as expeditiously as possible, and that may or may not, just to make substantial progress on this legislation, in the hopes that perhaps we'd avoid a ballot measure.
Also, by the time that we had publicized this meeting, hopefully more folks will attend or engage with us, that we can hear a lot more. So there's no expectation that we're going to agree on one plan A, plan B, or we create a plan C, but it's a good faith effort that we're putting on together as we share the importance of this on this issue. So now that we have a motion and second, let's open up for public comment on agenda item number 8,
What's the motion that?
to hold a special meeting on July 27th.
So we don't need a
Correct.
motion for that. We just informally discuss timing, but there's no motion needed for any special meeting, right?
Do you need a motion?
I don't think we. No, I don't think the commission
Action.
requires a motion. I think if you're all saying the 27th, is that what I heard correctly? The
Okay,
Wednesday, the
okay, no motion,
27th, we
okay.
can confirm the time of the morning to start, and start
we
as
will
early as
have a-
possible. But
okay.
we'll loop back with you. Thank
Okay,
you.
then we will have a additional meeting in late July, and the staff will notify the public ASAP when that may be. So let's open up for public comment on agenda item number 8, with the understanding
Before we
that-
move on, may I just, one last item, either for Mr. Canning or you, Leanne, is I would really appreciate a very strong, clear recommendation from staff on thumbs up, thumbs down, or suggested amendments by the meeting. Thank you.
May I provide one further point?
Please go ahead.
Thank you, Chair Lee. I want to provide a hopeful point that I can't promise this, but to Commissioner Romano's point about, a yay or nay vote on the 2 amendments and Mr. Canning's point about the commission being able to do amendments, it's also possible we are in discussion with Supervisor Peskin's office. We don't know where those discussions are going to go, but it's entirely possible that there could be a compromise piece of amendments, one set of amendments that all parties agree to, possibly. Again, we can't promise that, but that would be that could be a positive development, obviously. And at that point, if we were able to get that to staff so that it could be agendized in time for the meeting, it's possible there could, the compromise legislation could come to the commission for an up or down vote.
That would be the best case scenario that we can hope for. Okay, thank you. So let's open up for public comments, please, moderator.
Thank you, Madam Chair. There's some callers online.
Okay.
Stand by. Welcome, caller. You have 3 minutes.
Hello, Commissioners. This is again Debbie Lerman at the Human Services Network, and thank you for your earlier flexibility on public comment. As some of you know, we have advocated before this commission regarding behested contributions for about 60 years now, and we weighed in way back on the legislation that created local behested contribution disclosure requirements, which was our preferred solution. We also have weighed in on the later legislation that created a ban. We recognize the need to ensure that behested contributions don't contribute to a culture or practice of corruption, but we continue to be deeply concerned that the ban will create and is creating a chilling effect on the city's ability to raise philanthropic funds and support our nonprofit sector in providing crucial services to our most vulnerable residents. These concerns have now been shown to be a real threat. This spring, DCYF, in an apparent misreading of the law, shocked nonprofits with the announcement that $25 million for youth summer jobs would no longer be available. As a result, the city attorney has now told departments to submit all philanthropic requests for review. The mayor's office then sent a letter seeking clarification on the long list of examples, and the city attorney was unable to thoroughly answer more than half of those questions. These creations have and will create delays and barriers to the city's ability to raise funds, a situation that will exacerbate funding issues at a time when we have people living on the streets and maybe heading towards a recession. The legislation also sweeps up hundreds, if not thousands of people who attempt to influence legislation or administrative action. Just as with gifts, this is impossible to track. We are defining people as a restricted source merely because they express an opinion, even if they have no type of permit application or contract or financial benefit, and there's virtually no risk of corruptive influence. So we do ask this commission to move forward as expeditiously as possible to consider the the two pieces of amending legislation sponsored by the mayor and the board, and work with them collaboratively to address these problems with the law as quickly as possible. Thank you for keeping an open mind on these possible changes to the law.
Thank you.
Welcome, caller. Your 3 minutes begins now.
So, Commissioners, prior to this, there was some difficulty accessing public comment. And this has been a convoluted type of back and forth. SFPUC is responsible for a lot of this nonsense. And a gentleman from the previous city attorney's office, I mean, he was a city attorney. He's now the general manager of SFPUC. That in itself has to be looked into by the Ethics Commission. Another gentleman from the city attorney's office who worked there previously is now the deputy general manager. His name is Ron Flynn. And the general manager's name, who is now of SFPUC, is Dennis Herrera. And y'all are getting hoodwinked. Juliet Alice had over 200 boilerplate type of applications that people signed, and they got grants. On the the community benefits linked to the Bayview, people got $300,000 grants, not loans. And y'all are not taking this into account because y'all do not know exactly what is happening. Dwayne Jones, if your attorneys, he is into everything. He's not supposed to have any privileges of bidding, but he's into everything. And we're talking about $150 million. Juliet Alice, $150 million. And y'all are looking at it from some other point of view, which is really a waste of time. We need to go after the real crooks. They get up every morning and all they think is about cheating people. And all this started more from 1996. Let's find out who the mayor was in 1996. And y'all have no clue because chronologically, y'all are just, you just jumped the bandwagon. And y'all have no clue what you're discussing. Y'all have no clue how to do a needs assessment because y'all are not educated on issues. I see how y'all are talking about, let's have a special meeting, Yeah. Basically, you have to know Robert's rules. And basically, if you are good leaders, you would have had this conversation 3 months ago.
Caller, your time has expired.
I know it hasn't.
Caller, you have 3 minutes now.
Hi, this is Cheryl Davis, the director of the San Francisco Human Rights Commission. I just wanted to call in, first and foremost, I've shared this with staff as well. I have major concerns around how you define interested parties and who has access to the meetings, timing of the meetings. I'm very concerned about the unintended consequences of this work and that you haven't really done the work to talk to the nonprofits and folks. There are a slew of folks who have no idea that this is happening. And I'm very concerned that this is going to perpetuate the inequities that we're seeing happening in our city. I'm very concerned around how this is going to impact people of color and low-income communities. I have a lot more, and I've shared some of this with Leanne and others. On a personal note, I do feel that a lot of this is not even just about inequities, it's racist. Some of the language that is used, I think, is a dog whistle for Black people. That has been something that I've heard in other community conversations, that the fixation on individuals, and even to the point of the last caller, Mohammed Nuru and the things that happened recently, those are not the first time that there's been corruption, but the fact that on a personal level, it seems that the urgency and the fervor and the fever in which you all are doing is about the fact that Black leadership stepped out and that you have to address this quickly as if it's never happened before, to the detriment of several, if not hundreds, of organizations and community members. And so I think that not enough has been done to understand the unintended consequences. I think that people did not understand the legislation that was voted on. I think that there is a lot of confusion around when we say, of course, everyone is in agreement for stopping corruption, but this does not address corruption. This actually is going to create a space where folks who have not had access to philanthropic dollars, who do not have access to private dollars, are no longer going to be able to have access to that, which is going to further the divide. And it's also going to have a huge, huge impact on who is able to actually effectively do their work in community. So I have major concerns around this. I've not been happy with the process around outreach and engagement. And I think that there are some really strong racial implications that have not been addressed through this process.
Excuse me, I'm going to ask to, if we might just extend your comment for a minute, because I do have a question. I'm not quite sure your position. So you have, is it okay that we expand it? Are you still there, caller?
Yes.
Hi,
Yes,
I'm sorry, I missed your name.
Cheryl Davis, I'm
Hi.
the director of the San Francisco Human Rights Commission, and the Office of Racial Equity sits in my department.
Right, I heard your title. That's what grabbed my attention. Ms. Davis, so you're concerned with the mayor's proposal or the Board of Supervisor Peskin's proposal?
I'm concerned with all of it. When this initially started, I was told by Supervisor Peskin's office that someone would circle back before it was introduced. That did not happen. And to be honest, and I know Mr. Heckel has been involved, as we have other departments, I resigned myself a while ago to the fact that this is not going to be a fair process. That, by and large, unfortunately, there are a lot of laws and rules in the United States that are not just. And I just resigned myself to, this is going to be steamrolled through, and we'll work with the community to respond to the impacts after.
So you think the current statutes are best for the communities that you serve?
I think that the recommendations that Mr. Heckel and other folks have been making are going to be helpful. I think my concern is that we haven't really done a deep dive to understand the impact of this in the name of ethics, and we have not talked about and thought about who's going to be directly harmed by this. Unfortunately, equity is not about majority rules, and to be honest, I have been in and out of this. I need to do a little bit of a deeper dive, but I think that the initial, what was introduced, is problematic at best.
I'm very curious to hear more, and I hope that you can submit some more comments on that, because my impression is that everybody who is behind the proposals from Mr. Heckel and the mayor are trying to bring more money to underserved communities in San Francisco, nonprofit organizations, not hardly harm them, almost exclusively benefit them. So if that's not the case, we certainly want to hear about that.
I think in the name of building this, that Mr. Heckel and the other groups have tried to do their best to compromise. I am very concerned about the impact that it's going to have on staff, that it's going to have on, to be honest, and I've shared this with Leanne and others, it's just another layer of making work difficult to serve the most disenfranchised in the city, and it makes me wonder why anybody would want to work for the city.
So the amendments, okay, I'm confused about which make
the amendments I think are helpful. I think the amendments are helpful. Yes.
Okay, thank you. That clarifies things some. Any written feedback would be extraordinarily appreciated, I think, by all of us.
I will work with Mr. Heckel to get that to you.
Thanks.
Thank you, Ms. Davis. Next caller, please.
Welcome, caller. You have 3 minutes to provide your comments.
Hi, this is Lisa Pagan with the Office of Economic and Workforce Development. Can you hear me?
Yes, if you could speak slower and more clearly, it would be we could hear you better.
Okay, is that better? I hope so. My name is Lisa Pagan with the Office of Economic and Workforce Development, and I am calling because We strongly support the proposed legislation from the mayor's office, file 220733. Departments have spent hours and hours providing real examples and specific recommendations on how our fundamental work has been challenged to move forward. We want to, embrace ethics rules, but the legislation that was introduced and passed on behested payments has really impacted our ability to do our work, and we're spending an extreme amount of time answering compliance questions and doing administrative review. There's no master list of interested parties. All of our businesses that we work with in the city and county of San Francisco, they ask us, they provide us with ideas around policies. The number of, just regular folks we work with that, could be considered attempting to influence is quite large because of the work we do. We're supposed to listen to workers and businesses and help them through policy and program changes. But we then cannot work with them if they want to donate to discuss nuances about how best to do that because of their interested party status. The recommendations in Mayor Breed's legislation that she proposed really will help us continue the fundamental work of our department and help us do our racial equity work and do our development agreement negotiation work. So we do hope you have a special meeting this month so we can go in detail over every amendment proposed and discuss many examples of why we think they're necessary. Thank you for your time and consideration.
Thank you.
Madam Chair, there are no more callers.
Okay, thank you so much.
Can I just briefly respond to Mr. Heckel's last comment? Ms. Heckel had alluded to a potential, meeting with Supervisor Peskin's office to perhaps create a revised version or merged version of the proposal being considered. Just to communicate that hopefully the Ethics Commission staff would be invited to participate in that discussion as well prior to the special meeting upcoming if one happens.
It's good to know. You mentioned that it would be nearly impossible to have an interested persons meeting before the 27th, but given the interest and offers for help from Ms. Davis and a couple of other speakers, do you think you can put together a Zoom meeting, just send out the email and have Mr. Cox, Ms. Davis, and Ms. Lerner to just bring in a few of their stakeholders so that there could be a discussion from the frontline stakeholders that would really help us better understand the impact when we meet on the 27th. Is it possible? We're looking at 2 weeks timeline. If you can engage 2 or 3 of the callers, because I do think that they have raised some really important points that we were not privy to because we most of us do not travel in that universe. And their voices are very important for us to really understand. So, Mr. Canning, is it possible for you to hold informal meeting with, a few of them before the 27th? So by the time you put together a proposed actionable item for us to consider on the 27th, it would be inclusive of all diverse voices.
Shirley, if I might just jump in, I actually would like to answer on behalf of Michael Canning. I think Michael Canning's answer would be, I'd love to be able to try. My answer as your executive director is I think that's virtually impossible. The meeting that will be on the 27th, we will have to notice publicly on the 22nd. So we would need to have the IP meeting essentially next week to be able to pull in the information, consolidate it, make sense of it. At the same time that Michael and I will be working with Mr. Heckel in the mayor's office and Mr. Peskin's office, hopefully, to have conversations about this, at the same time that we're going to try and close out meet and confer on the ballot measure and the gift issues. I do not like being in a position of saying no. I'm just trying to give the commission a sense of where we have bandwidth and where we do not, unfortunately. I think what I would suggest is that the comments that we've been hearing from the number of the callers today representing city departments, those comments are being very clearly conveyed through the mayor's office and Mr. Heckel's comments as well. And my recommendation, just for what it's worth, is that I think those comments might be best framed when there is something new to react to at the July 27th meeting that perhaps reflects some common ground among all three offices or specific pointed recommendations that we can bring to you. So I just wanted to offer that. I think, if the commission is committed to being on a Zoom call to take input, more public input, we will make that happen. But it is extraordinarily difficult for me to envision that we've got a bandwidth to do that well for you in ways that we couldn't achieve otherwise.
And I would add that we haven't heard anybody who's opposed to the proposals, I don't think.
Well, we haven't heard anybody who sparked conversation from Mr. Peskin's ordinance, which may not be exactly aligned with the mayor's ordinance.
But
I'm
even
not sure we know.
I mean, they passed these rules to begin with, right? The behested payment law.
Yeah, unanimously.
Somebody was supportive of that.
Well, if people are eager to share their opinion, I think they'll find a way to share with the staff. So I understand the time constraint that the staff is under, and I have to remind myself this actually is a very small staff commission. The staff are asked to do 10 times more of the work that they should be doing. So I would encourage the public, for those of you who have strong opinions on this, let us know. And we definitely want to hear from everybody, and it goes two ways. If you really want to share your perspectives, please either write to the office or participate on the 27th. So if there's nothing further to discuss, agenda item number 8 is closed. Agenda item number 9, discussion of executive director's report, which is...
Thank you, Chair. Commissioners, I will be very, very brief, given the lateness of the hour. The only thing that I want to highlight from this month's report is the very good news. I'm excited to share that we have a new Ethics at Work Training and Outreach Manager who will be joining us on June 25th. So jumping right into a very busy time for us, we're excited to welcome Peter Lauterborn to our staff. Peter has had extensive experience in the civic engagement and public engagement space. He's a former city employee, worked with former supervisor Eric Marr, also had experience with the Department of Children, Youth, and Families prior to that, doing outreach activities on voter education and civic engagement. And most recently, he's been with Civic Edge Consulting, which I think prior to the 5 years was called Barbary Coast Consulting. So Peter has an extensive experience in communications and outreach, and we're looking forward to having him come on board with his expertise and join with his level of energy, his vast public sector experience and skill set. So we're looking forward to introducing him to you at a commission meeting soon.
That's great.
Thank you. If there's no comments from the commissioners, let's open up to public comments, please.
Thank you, Madam Chair. Madam Chair, there's no callers on the line. Madam Chair, there's no more callers on the line.
Okay, terrific. Now we're going to agenda item number 11, which is discussion and possible action on items for future meetings.
Can I weigh in on this, or is this just public?
No, this is for us.
Oh, good.
Yeah.
For future meetings.
Yes.
This is not an urgent matter. I would love to find a way to think about how we can make these meetings more efficient and streamlined and shorter, whether that's amending our bylaws, making the script shorter, putting time limits on people, reducing public I don't know. But I would like a proposal from staff. It's not urgent. We have a million things on our plates, obviously, but I'd love to think about how we can do that.
Just a quick question to the executive director. Since we have hybrid meetings among different commissions, has other commissions talked about the additional time that it needs just because we have a hybrid meeting model now compared to in-person meetings before?
That when we were fully remote?
Yeah.
Yeah, I don't know the information. I can ask. I don't know how other of the charter commissions have been experiencing this hybrid format. But I'm certainly happy to ask and inquire. If the commission, if the commission's preference is that and experience is that the meetings have been shorter and more efficient, not in a hybrid setting, that's, helpful feedback to hear about. We can certainly learn more
One
from
way or another,
other
it's
commissions.
just that,
I'd be welcome to hear any
balance it, it's
feedback
just-
that any of our commissioners have based on your experience so far.
Okay.
One just question on that. Is there limits to what can go on the consent calendar? Can anything go on there? Because that would expedite a lot, because that wouldn't require public comment on each item separately.
My experience is, Commissioner Finlev, is that the consent calendar is meant to be anything that is expected to be non-controversial that the commission does not feel the need to discuss.
Right. So I could see like the ED's reports or other informational items from the staff could go on the consent calendar because they're not controversial. They're super informative, but they're not really. So just a thought.
And
out
just
there.
some clarity on like what we need votes on. Obviously, we've learned today we don't need votes on when we have scheduled hearings. We probably don't need votes or public hearings on your report, for example, or public comment on your report.
We do need
Public comment has to be, there needs to be.
For example,
Only because it's agendized.
right. For example, the executive director's report doesn't necessarily need to be on every meeting agenda. It could be every other month, or if Leanne feels like there's something that she wants to address with the commission.
Or if we should amend bylaws that we don't have public comment at the beginning and at the end. I just don't know I'm not saying that those are all the best proposals. I just like to think about how we can.
Well, I definitely think that we can consolidate some of the public comment agenda items. Right now, we have like 3 that could be combined to 1.
And would we then
Additional
just expect,
opportunities, non-agenda items, that could be combined into just 1 instead of 2 or 3.
would we then just expect the public to reach out by email or call if they had a comment? Because I worry about, kind of narrowing or reducing the amount of exchange that we have with the public, given our position. So just wondering what the other channel would be, or what we would expect the other channel to be.
I think there'd still be public comment, but if more items on the consent calendar, there'd be 1 public comment for the 10 items on the consent calendar, as opposed to 1 public comment item for every item separately.
Okay.
Yes.
Yeah. So it would be maybe public comment goes for 20 minutes because it's on everything on the consent calendar.
If there are 20 commenters
Right.
or if
Okay.
7 commenters.
Okay.
My math.
Well, I think that we could limit it to 2 minutes because I know that in previous commissions, when we have like 50 people waiting in line, everyone gets 1 minute.
Yeah.
So it's up to us to decide. So we can change it from 3 minutes.
It can also depend on how many people are online. If there are lots of people online, then you limit it to
The
shorter
issue
periods.
itself. The only thing is we have to be fair. It has to apply to everybody. And
Right,
I do think that for the public comment for item, I do think that people tend to have different responses after discussion from this commission, after presentation from the staff. So instead of having them just comment on all agenda items, it would be beneficial for, at least for me, to hear public comments after each agenda item is introduced, which is unfortunate that we have so many agenda items. But we'll work on it, and maybe the executive director and I will go over some of the areas that we can just.
I believe we do have 1 member of the public in the caller queue as well.
And Mr. Chen.
Oh, my apologies, didn't see you.
Are ahead of the discussion about public comment. It will be difficult for the commission to lower it below the current 3-minute allotment. As someone who recently advised the redistricting task force, I will let you know that this is not an overwhelming amount of public comment compared to what most commissions receive. For most items, I believe we had less than 10 people. I don't believe we reached that threshold for any item today.
No, I don't mean the numbers of people who can call in, but the time.
The
We
num-
could set
Yeah,
where
that's what
there's
I'm
1
referring
minute
to.
3, right?
It should be. I think it should stay a 3 based on the normal number of people who would tend to provide public comment.
Okay, thank you. Okay, if we, moderator, did you say there's no public comment on agenda item number 11? Oh, no, I apologize. So late. After Commissioner Romano made the comment. So now let's open up for public comment for agenda item number 11, please.
Pesado, you're muted.
You know, commissioners, I think you're insulting the public. And y'all need to read the Brown Act. So why don't we limit your conversation to 3 minutes, or at the most 5 minutes, instead of y'all going in circles? I mean, I haven't seen a commission like the Ethics Commission, you know, rambling and rambling and rambling, and then they say, oh, you know what, let's limit the time for those who call. How many of us call? Most of all are disgusted with the Ethics Commission. You know, the only good person that we find on the Ethics Commission is Larry Bush. We respect him. The rest of y'all, you know, just like, you know, sidekicks, you know, give the mayor a chance, mayor's office a chance to join your conversation, and that guy is like throwing some arrows in the air, and y'all accept that type of thing. If y'all are educated on issues, if y'all are good leaders know the way, show the way, and go the way, you will limit your conversation. We are fed up with you. We just have to, for example, have to listen to the Ethics Commission so that I can mention y'all in my blog. And I have stopped mentioning y'all on the blog, but I will now, especially the director. The director should have had all these things in place 3 months ago, if not 5 months ago. The city attorney should advise the director. You can't bring these matters at the last 11th hour and then accommodate the mayor. The mayor says, oh, she may not. You know, it depends on Paskin. No, the Ethics Commission, you know, y'all can make the decision. Y'all can plan it. Y'all can have your short-term plan, your blueprint, whatever, and put it 3 months before it comes to be submitted to the ballot. And one of our commissioners, you know, oh, you know, it takes this. Hey, I put about 40 issues on the ballot in my 40 years. You think I don't know what it requires? It requires you to be educated on issues. If you don't want to be on the commission, step down. As far as the people are concerned, and as far as my group is concerned, they're not impressed with y'all. They're not impressed with y'all. The only two people we were impressed with was the former judge and Larry Bush. The rest of y'all can resign. Y'all don't know what is happening in the city. We are the ones
your time is up.
who worked hard.
Okay, public comment is closed for now. Let's go to agenda item number 12, additional opportunities for public comment on matters not appearing on the agenda.
Madam Chair, there's no callers on 12.
Okay, thank you. Agenda item number 13, adjournment. No comments and no public comment. It's closed. Happy Friday. Happy weekend, everyone.
Happy weekend.
Thank you, Mr. Moderator, Mr. Delgado.